And in the meanwhile, I have also filed the petition for withdrawal that is not tagged with the record. So withdrawal may be allowed and registry may be directed to tag that record along with the case records.
Right, we will we'll call for the petition in the second half.
At 2 p.m.
At 2 p.m. 57.
My lord.
Keep petition on the way.
Yesterday, your lordship allowed my prayer for listing of this matter for tomorrow, 17. But due to as the server was down, my lord, in time I could not collect the filing number. By the time it was given, all the mentioned memos were sent.
Motion.
Tomorrow.
Yes. Proceed with the consent of the petitioner, my lord. I beg to mention item number 2 of today's list, my lord. This is 2012 matter.
Yes.
So we are awaiting the instruction, and in the meantime, my lord, in a similar matter which was allowed by this honorable court, my lord, the finance department has prepared a writ appeal that was dismissed on the ground of delay. Now the department has gone to the apex court. So I pray for 4 weeks time.
We close this matter. You go to the Supreme Court together.
Otherwise, my lord, we are awaiting the instructions.
What instructions? You say similar matter has been disposed of.
That is true, my lord.
So it will be covered and disposed of. 2012 matter. Why should we be kept waiting for instructions?
As a matter of last sunset.
No. Please, you get that order. You get that similar matter order and the writ appeal order. We'll close it.
My similar order I had annexed with my additional affidavit.
Whatever, if it is there, then it is there. If it is not there, you get a copy.
Right.
We'll examine it.
But I have another prayer, my lord. Item number 5, my lord. I am seeking an accommodation for 4 weeks, my lord. I am awaiting the instructions, my lord. I have taken the consent of the petitioner. Post the Pathat, my lord. I have taken his consent.
Item 5 only.
Item 5, my lord.
Request made by Mr. R. Borpujari, Counsel to the Finance.
Finance, my lord.
Matter stands deferred to be listed after 4 weeks. He submitted the consent to the Counsel to the petitioner is also made.
I am so obliged.
Motion matter. When was it filed?
Today, my lord.
So today it will come on Friday. Why tomorrow?
My lord, there are some urgency.
What urgency? Why file it today? What is the urgency?
Urgency, my lord. In 1 or 2 days now will be dismissed from service, my lord.
Doesn't matter. Friday.
My lord, kindly, my lord.
Friday.
Otherwise,
if it is dismissed, we are not powerless to stay that order.
No, my lord. Kindly, my lord. Otherwise,
we are not powerless to interfere with the dismissal. So have it on Friday. You are not there on Friday. Yes? Yes or no? Yes or no? Say that. Why do you forget I was on the other side for a substantially longer time? All right, tomorrow.
Praying for listing of the petition on Friday, Lordship.
For what purpose?
For admission, Lordship.
Admission matter.
Lordship.
Admission, the pleadings are exchanged.
Exchange, Lordship.
All right, then let it be on. Because Friday is the last working day.
Yes.
Then let it be on after vacation.
Lordship, the problem is that the posts which have been there, it may be filled up by this time, Lordship.
All right, then 23rd.
23rd.
May I please, your lord, I beg to put one admission column.
After vacation? Before any date is not what is there any urgency that it can't wait for 1 week, 2 weeks?
Last listed on 9/5/2025.
25. And you suddenly want the urgency is there. No. After vacation. On 24th. Sorry. Admission pleadings are exchanged?
Yes.
Pleadings exchanged?
Yes.
23rd July.
Wait, please, Lordship, I beg to mention item number 8.
8.
Will file our affidavit and reply. You have taken consent. The matter may kindly be adjourned for today, Lordship.
You are for the petitioner.
Petitioner, Lordship.
Item 8 on the request made by the counsel for the petitioner stands deferred to be listed after 4 weeks, enabling him to file additional affidavit. It is submitted. Consent of the counsel to the respondent will be free.
Lordship. Much obliged.
Regarding admission matter, we say school managing committee. So my building is completed. So
School managing committee. School managing. Then it must be education bench.
Bench too.
Only in Lordship.
It must be education bench.
May I please, sir? I'd like to mention item number 70. In this case, respondent have filed affidavit yesterday. It may be called on record.
Item number
70, my lord.
70.
Yes,
70.
may be called for record.
We'll see. What is the matter here?
Arbitration, appointment of arbitrator, my lord.
Okay.
Okay.
Yes.
May I have your lordship? So with the concept of the other side, rectification item number 38 to 43. Here lordship, they have filed affidavit in opposition lordship. I will file reply lordship. But immediately after vacation lordship, in the meantime, I will file the reply.
38 to
Lordship,
43.
39 is not to me lordship. 39 is what same matter with.
What is the matter? What
Lordship,
are these
regarding
matters?
the appointment of constable lordship
And rejection of prayer on the EWS.
and they saying that although we have submitted EWS certificates lordship, the authority said that we have not submitted the relevant EWS certificate for the year 2020 and 24. But at the time of document.
Wait. Let these matters be called up. These are all connected matters.
Yes, yes.
Only
38 to 43,
38 to 43.
lordship.
Right, you wait. Let the matter be. Let it be called up. We'll pass over this.
I'd like to mention for listing the admission matter on maybe Monday.
Not Monday. Why the urgency on Monday?
Matter relates to petitioner challenge the review, report of the review medical board.
Let it be on 30 July.
Like
30 July.
May I please your lordship? Lordship, I am praying for the listing of the writ petition, lordship, for orders column, lordship,
Why?
on Friday, lordship. In this case, lordship, petitioner challenged the transfer order, lordship, which was cancelled, lordship, and matters become infractuous, lordship.
Infractuous.
Yes, lordship.
Let it tomorrow. Why Friday?
Obliged, lordship.
Please, the lordship, I'd like to mention item number 66, lordship.
66.
Lordship,
Yes.
yes, lordship. This matter may come up after vacation, lordship.
Any objection from the respondents?
No, lordship, I have taken the consent, lordship.
Item 66 on the request made on behalf of the council for the petitioner stands referred to be listed after 4 weeks.
May I please, your lordship? But I like to mention for listing 3 petitions. Well, similar matter, well, your lordship speaks on 16/7 after vacation 16/7. But matter pertaining, my lord, pensionary benefit of workers employees, my lord. And the Honorable Supreme Court have already disposed of the, my lord, the petition Shukendra.
All right. Send 16/7.
Yes, my lord. I know.
I'd like to mention items 67 and 68 also. There is hearing matter. Lordship may adjourn this matter after it's come up after vacation, some passing. I've taken consent from the,
You are for
I'm for a petition.
petition.
After vacation.
67 and 68. On the request made by the council for the petitioner, Mr. A. Chetri, matter stands referred to be listed after 4 weeks.
Lordship. The concern of the other side, I beg to mention item number 44, lordship. In this case, on the last occasion, records was called for, lordship. Probably records are also not there, lordship. On 29th of July,
Receive the report. Records has been
Records are received. Item number
44.
44.
44.
Readings are completed
So pleadings completed, let
Yes,
it
sir.
be heard.
after vacation.
This is what records are there?
Lordship, regarding termination of service.
Disciplinary. Disciplinary proceeding matter then heard counsel for parties issued records called for. Matter be listed for hearing in the month of August.
Can be on 29th of July.
No, August.
Can you get me fixed?
No date. It's coming for hearing part 2. Part 2 hearing list.
August. Obliging.
Yes.
Respondent that Ms. Sharma is on legs in court 1. She is requested to take the matter after some time. Lordship had asked them to bring the records or whatever relevant
For some time.
after some.
Where's the petition?
May I please your lordship, as a respondent number 6 and 7, we have been implemented, but the copy of the petition not been served, lordship. So we could not file the reply, lordship. 2 weeks time may be granted to file our reply, lordship. As copy of the petition has not been served to us, lordship.
There is none appearing for the petitioner. None appears for the petitioner. It is submitted that by Mr. S. Sarkar, S.K. Sarkar, that the respondents have been respondent numbers
6 and 7, lordship.
6 and 7
Seven.
have been
Implemented.
and a post title, amended post title has been
Lordship, as per the office note, the amended cost title
the
also.
amended
there is
post title has
difficult-
not been filed.
It has been filed, but there is some defect in the page numbering or something like that, and that is why it could not be done. The office note indicates it.
I will do one thing that as per office note 15/6/26, amended post title for implement of respondent 6 and 7 will be incorporated in the record as well as the CIS due to improper pagination. So petitioner is permitted to rectify the defects and have the matter listed again.
And copy may be served, lordship.
And counsel for the petitioner will also ensure service of copy, the writ petition. On the respondent.
6 and
6
7,
and 7.
lordship. Highly obliged, lordship.
Ms. P. Agarwal for UGC, Ms.
P. Upadhyay,
G. Upadhyay for
on behalf of Mr. S.C. Kyal, Lordship.
behalf of Mr. S. Kial for the university.
Yes, Your Lordship.
Highly obliged.
May I please, my lord, I was directed to submit the original records, my lord. I have arranged the records, my lord, in 2 bunches, my lord. The first bunch, original, the proceedings are there, and in the second bunch, my lord, all the exhibits are there. And in the first page, my lord, I have noted, my lord, all the article against which, my lord, which exhibits have been relied on, my lord. Article 1, which are the exhibits relied on by the inquiry officer, my lord. So this way, my lord, I have arranged the record. And my lord, only the one thing is that, my lord, here the exhibits are from P1 to P32. And P2 and P3, my lord, that is in a pen drive, my lord. It is a video recording, my lord. That is also I am producing. Video clip of a news item, my lord. P2 and P3, my lord.
Can printouts not be taken?
Your
It's
recording.
a
Recording.
video recording.
Yes, my lord. News item, my lord. 2 news items. Of 2 news channels.
Let us see the record. What is there?
Statement of the witnesses, Your Lordship, whether the witnesses approve the allegations.
Your lordship peruses the inquiry report, every charges, my lord, that is based on some exhibits, my lord. So accordingly, I have arranged that, my lord. Article 1 based on which exhibits, my lord.
No, so where does one find in page numbers?
My lord, in the second bunch, all the exhibits are there, my lord. The second bunch, my lord. P1, P2, that's where I have flag marked also, my lord.
Where are the depositions?
Depositions are also there, my lord. Depositions. Depositions and all the relevant documents that has been relied by the inquiry officer, my lord.
Where are the depositions?
Written depositions are there, my lord.
Where are they?
There, my lord, I can point out. So the second bunch, my lord. My lord, one more thing is that, my lord, while the inquiry officer, my lord, not only the deposition, because the documentary evidence also they have taken into consideration in respect of all the charges, my lord. So in this bunch, my lord, I have arranged while taking a decision on Article 1, which are the documentary evidence has been relied
No,
upon.
that we know, but we want to see that was it also proved by any deposition of any, what are the
Yes,
depositions
yes,
of the
there are
witnesses?
depositions of 2 witnesses, my lord. Lord, that is one is P28 and another is, yes, my lord, P28. My lord.
Sub charges dated 15/9/16.
What are your grounds for challenge of the?
First of all, my lord, we have not been
Sir.
provided with the article of charges and the,
Your claim is that you have not been served.
yes, and no, second is, my lord, the article of charges have not been proved by the witnesses, which is required as per the
No,
Supreme
no.
Court decision.
This is ex parte.
Ex-
Ex parte. So
Yes.
your first ground is that you never served.
Yes, and even expertise has been, my lord, the dismissal order has to be proved. This has not been done. But I have given a small note on the list of relevant dates. If I may take your lordship through it for a moment, my lord,
Yes.
that will cover the story. If your lordship takes this, my lord. This small notes is there.
Yes.
This is the other background of the case. He was suspended. Annexure 4, my lord, if your lordship takes these notes itself, it will cover.
Yes.
Then annexure 4, my lord, explanation notice issued by the respondent number 4. These are the allegations. Then ultimately, my lord, they have reinstated the petitioner. Your lordship will kindly see paragraph page 55. Page 55, but this was not served to them. And case was pending before the court as regards suspension order. It says, my lord, Hemanta Sharma, who was suspended from service so and so, is hereby reinstated in his post in consideration of his apology letter, and that it being the first offense in his service. He is, however, issued this stern warning to conduct himself in a way befitting a government servant and not to indulge in insubordinations and subversive activities in future. If such activity is detected, strict disciplinary action shall be taken. This was also not given to the petitioner. So he got it during the pendency of a writ petition filed by him. Now again, show cause notice was given at page 59. Page 59. These are the page 59. Then he has given a reply.
Yes.
He has given a reply as
No,
page
again,
50.
show cause means this is after the inquiry report.
No, after the reinstatement.
After the reinstatement.
This your lordship will kindly see because of.
No, but
because of
these are
page 659, your lordship will
you
kindly
were
see.
suspended,
Then reinstated. But the reinstatement order was not given to me, so I could not join. So we filed again, my lord. They have given me a show cause notice at page 59. Show cause notice, that is mainly because, my lord, your lordship will kindly see page 59. Page 59.
Yes.
You have been absent from duties till date without any information to the so and so. The allotment suspension of the order to submit non-engagement certificate, not allowed to put signatures. So you will remain absent after withdrawal of suspension order. So therefore, this show cause notice has been. So he has given his reply, that is at page 60. He has shown that as on date, I have not received the order of suspension and withdrawal, order dated so and so only. I come to know this from your letter dated so and so. Hence, with this response, I have clarified your letter dated so and so. So I have prayed for you that I want to join my duty from today. So after this, my lord, they have again order of suspension at page 63. This is for non-disclosure of his arrest in connection with his personal check bouncing case. So because of that, he has been placed under suspension. That is at page 63. Then thereafter, my lord, an ex parte inquiry proceeded. An ex parte inquiry report we have received. That is at page 64. And ultimately, page 74 is the dismissal. And appeal was, we have filed appeal. We have said that we have not been heard, and appeal was also dismissed. So this is the case in short, my lord. And your lordship looks into the records. The record will show that there is an article of charges dated 15/9/2016.
1 minute. Where is the dismissal order?
Dismissal order is at page
76.
74, my lord.
74.
74.
1812.
Yes. The ex parte inquiry report is page 64. We have stated that we have received it affidavit in opposition filed in WPC 312416 relating to the suspension case. Now, from the record, your lordship will find there is an article of charge dated 15/9/60. As many as, my lord, 9 charges are there.
Yes.
15/9/16, as your lordship got it.
Page number
And that is from the record.
from the record. No,
Because the ex parte proceedings, they did not give us this.
you never received the show cause.
No. Article of charges we have not received. We have received the inquiry report, they didn't just read it.
Against this order of dismissal, you filed an appeal.
Again, yes.
Where is that appellate order?
The appellate order is that. That order is 132. Page 130. Now, our appeal mandate at page 90, we have stated that without hearing us. Now, from the record, your lordship sees the record. Record will show that there was an article of charge on 15/9/60. As many as, my lord, 9 charges are there. Engaged in the affairs of publication of newspapers, engaged in the mobile theatre group. As your lordship got it. Now, in the note I have written from the record itself.
Yes.
Then wife submitted representation for transfer, did not report about arrest. He was arrested in connection with check bouncing case to private matter. Failed to maintain decent standard of conduct. Defamatory news published. Disobeyed lawful and reasonable orders of disciplinary authority. While under suspension, issued show cause notice but could not convey that his written statement was satisfactory. Conduct unbecoming. Misbehaved with Dr. Bora, respondent was so and so. Filed FIR against Hemanta Shah. My lord, list of documents they have relied on this attendance record, press report, letter of Sankari Borua, wife, report from Testu police stations, paper cutting, letter of Hemanta Sharma dated so and so, all orders issued that year, all show cause notices and replies, FIR lodged by Dr. Bora, personal file of Hemanta Sharma. Then oral witnesses 3. There is no video recordings. List of oral witnesses, Dr. So and so, so and so, so. My lord, if your lordship looks into the, my lord, only 2 witnesses, as my learned friend has said, submitted, my lord, only 2 witnesses deposed. Whether they have proved all the allegations leveled against the petitioner as per article of charges. The lordship will kindly see that, and whether it is in tune with the judgment passed by the Apex Court in 2024 SCC online, Supreme Court 3325, which I have given to your lordship at paragraph. That note also I think we have given. Whether the statements of the witnesses, whether it covers all the allegations.
What is the judgment?
And the judgment is at page 24, Supreme Court matter. I have given you to lordship.
What is the name? Satyendra.
Certainly. May I read that paragraph
Yes.
10 onwards? Is Rule 7, ours is Rule 9.
Yes.
Rule 7 of the rules of 1999 prescribed a procedure for imposing majority penalty would be applicable in the inquiry to be conducted against the appellant to bring home the charges imputed to him. Rule 7 of the rules very clearly stipulated where government servant denies the charge, the inquiry officer shall process to call the witness proposed in the charge sheet and record their oral evidence. I skip, I go to paragraph 13. This court in a catenary of judgments has held that the recording of evidence in a disciplinary proceeding proposing charges of a major punishment is mandatory. Reference in this regard may be held to Rup Singh Negi case and so on. In the case of Rup Singh Negi, this court held that mere production of document is not enough. Contents of documentary evidence have to be proved by examining witnesses. Indisputably, in paragraph 14 quoted, a departmental proceeding is a quasi-judicial proceeding. The inquiry officer performs a quasi-judicial function. The charges leveled against the delinquent officer must be found to have been proved. The inquiry officer has a duty to arrive at a finding upon taking into consideration the materials brought on record by the parties. The purported evidence collected during the investigation by the investigating officer against all the accused by itself could not be treated to be evidence in the disciplinary proceedings. No witness was examined to prove the said documents. The management witnesses merely tendered the document and did not prove the contents thereof. The record shows here even the document was not tendered. Reliance inter alia was placed by the inquiry officer on the FIR, which could not have been treated as an evidence. I again go to paragraph 15. We have noticed here in from subparagraph from 14, we have noticed herein before that the only basic evidence whereupon reliance has been placed by the inquiry officer was the purported confession made by the appellant before the police. According to the appellant, he was forced to sign on a said confession as he was tortured in the police station. The appellant, being an employee of the bank, the said confession should have been proved. Some evidence should have been brought on record to show that he had indulged in stealing the bank draft. Admittedly, there was no direct evidence, even there was no indirect evidence. Now, paragraph 15, same view was reiterated in the state of Uttar Pradesh versus Saroj Kumar Sinha, wherein this court held that even in an ex parte inquiry, it is the duty of the inquiry officer to examine the evidence presented by the department to find out whether the unrebutted evidence is sufficient to hold that the charges are proved. The relevant observations made in Saroj Kumar Sinha are as follows. An inquiry officer acting in a quasi-judicial authority is in the position of an independent adjudicator. He is not supposed to be a representative of the department disciplinary authority government. His function is to examine the evidence presented by the department even in the absence of the delinquent official to see as to whether the unrebutted evidence is sufficient to hold that the charges are proved. In the present case, the aforesaid procedure has not been observed. Now, paragraph 16. In the same view has been taken, only rendering the documents will not do, or keeping some documents in the file and without the same being proved by the witnesses. That is not sufficient. You have to prove the documents, on not only the documents but the contents of the documents also. So, in the case of Nirmala Jhala, this court held that evidence recorded in a preliminary inquiry also cannot be used for a regular inquiry, as the delinquent is not associated with it, and the opportunity to cross-examine persons examined in preliminary inquiry is not relevant extract of the same is given. And what we find sometimes disciplinary authority, they rely on only the preliminary inquiry report and they do not look into anything else. The court says, no, you cannot look into that, it has to be proved in the disciplinary process. Thus, paragraph 7, thus, even in an ex parte inquiry, it is sine qua non to record the evidence of the witnesses for proving the charges. Having tested the facts of the case at hand on the touchstones of the rules of 1999 and the law as expounded by this court in the Rup Singh Negi case, we are of the firm view that the inquiry proceedings conducted against the appellant pertaining to the charges punishable with a major penalty were totally vitiated and honest in the eye of law, since no oral evidence whatsoever was recorded by the department in support of the charges. So this is my case here also. Your lordship will kindly look into the records and see the statements of the two witnesses and whether it proves the article of charges dated, my lord, 15/9/2016, as many as 9/9. So my lord, we have looked into the record. I find, my lord, nothing is there as regard the article of charges. No witnesses have proved the article of charges. So in that view of the matter, my lord, in view of the judgment and because of the faulty procedures adopted by the authority, my lord, this dismissal order is liable to be set. There is another judgment which I have given, my lord. And there also same thing. That is,
Ajay,
yes, paragraph 25 to 20. Same concept. My lord, main thing is that, my lord, that article of charges, one has to take into consideration the witnesses has to prove all the article of charges. Merely the article of charges and documents being present in the inquiry proceedings of the inquiry file, that will not prove the article of charges. It has to be proved by the witnesses, not only the documents, but the contents of the document has to be also proved. So I find from the record, nothing is there. So they have said, the witnesses have said something about absence from duties. That is not even a charge. So therefore, I humbly pray, my lord, taking into consideration the judgment passed by the apex court and looking to record, this order of dismissal is liable to be set aside.
yes. Mr. Bora?
My lord, I have produced the record, my lord, because the petitioner, my lord, he intentionally avoided the proceedings, my lord. So all the notices, all the communications were made in his given address, my lord, the official as well as his residential address, my lord. But he avoided to
What
receive.
do you say with the submission that ex parte hearings
Yes, my lord.
also require proof of the allegations?
My lord,
By
that
the
proof,
inquiry.
because that judgment says when the delinquent officer denies, my lord, then because that judgment, my learned senior has referred, my lord, that judgment says, my lord, paragraph 14.
That is the judgment where even on an admission,
Yes,
the court refused to accept, say that their admission under these circumstances is not enough.
yes,
You have a duty to arrive at a finding.
yes, my lord. That finding, your lordship will find that all the documentary evidence that has been discussed in detail, my lord. In records, your lordship will find how they have arrived at the conclusion, how they have arrived at the particular search, my lord, the inquiry officer, my lord. It has been discussed in detail, my lord. And my lord, that the judgment also says, my lord, rule so and so clearly stipulates that where a government servant denies the charges, my lord. Here, my lord, he avoided to face the inquiry proceeding, my lord. And when he refused to receive all the communications, my lord, ultimately there was a paper publication also in the widely circulated Assam Tribune, my lord. That was also done, my lord. Because, my lord, in the given address of the petitioner, my lord, all the several communications were made. In fact, 1 or 2 communications were received by his wife, my lord. And she also communicated. Her communication also admits that, my lord, while he is pursuing government servant, my lord, he was running a newspaper also, my lord. And secondly, my lord, even after his reinstatement, he did not join his duties. Because, my lord, the fact is otherwise that, my lord, he was not in a position to join his duties because he committed several misconduct. He collected money from several persons, my lord, for giving the job or something like that, my lord. And that's why he could not attend his duties, my lord. As of today also, he cannot attend his duties. Unofficially, I can say that, my lord, because there are as of today, my lord, many persons are coming to the department looking for him, my lord. But otherwise, my lord, all the documentary evidence have been discussed in detail while arriving at a conclusion regarding all in respect of all the charges. Your lordship may peruse the record and documentary evidence are otherwise sufficient, my lord, to prove all the charges, my lord. Because his conduct, my lord, right from his suspension, my lord. Not Otherwise, he could, he was well aware of all the proceedings, although he did not receive the correspondence officially, my lord. He was all, and when he himself was running a newspaper, the newspaper publication, at least he should have known, my lord. And it was widely circulated, it was circulated in a widely circulated newspaper, my lord, the Assam Tribune, my lord.
All right. You dictate orders on 26th.
Yes.
Apply. Your Lordship.
Right.
My lord, this note your lordship will tell you.
Records have been placed in the arguments are concluded for orders on 26th.
And if your lordship wants that two video clips, my lord,
Give it to the court master. Keep it. The reports are here. The reports. That's it. Oh, regular. The pen drive will be 26th. Okay. So this possible.
The video clip is not in the charges of Mr. Witness. Let him give. Give them.
Matter after some time. Sir, Pujari and another good. He mentioned this matter in the morning, madam.
Okay. He mentioned that he wanted adjournment.
Fine.
Let him come.
Fine.
After some time.
My lord, these similar matters are being fixed on 16/7, my lord. This is regarding regularization, my lord.
Yes.
No, my lord, my prayer is that my lord fix matter on 16/7, my lord.
One. These matters are fixed on
16/7, my lord.
16/7.
Fine.
Relist his matter on 16/7 and it is submitted to the bar that similar matters are fixed on 16/7. Give us one number at least.
My lord, I will get the number, my lord.
Give it to the court master.
My lord.
Yes.
Yeah, please. The meetings are completed in this matter, right? So, initial hearing after petition it takes mind.
Where is the petitioner?
Filed an affidavit stating that GC does not have any role in this particular matter because it's a technical education institution. And UGC does not have any control over technical education institutions. It is the EICT. But EICT is not a party in the institution.
All right, time being, let the petitioner come.
Lovely.
Lordship, on last occasion, I was asked to receive instruction, Lordship. Lordship, we haven't received the paper from that which has been stated by the government.
Which have been stated by the,
They have sent that later.
Earlier, we had sent the proposal to the AG. The AG returned back the proposal, pension proposal, saying that there are certain rectifications need to be done. So we again sent it. Now, they are sent actually, we need relaxation in the rule 06 of the pension rules on the governor. So we have placed it before the governor. This is the latest statement.
Only after that we can act.
Now only after governor relaxes the period with regards to giving. I'm sorry, not that instruction, Your Worship. It's the instruction. It's
why the delay occurred?
Worship, the pension papers were sent in the year 2015.
Hmm.
And he also submitted the papers because he was actually compulsorily retired for mental disorder. He submitted it late, so we had to send it.
Hmm?
He submitted the pension papers lately.
No, you said it was submitted in 2015.
15 because he submitted
When did he retire?
2007, compulsorily retired due to
Retired.
mental disorder.
So when were the papers put up? Forwarded by the department?
Your Lordship, in 2015.
Why?
In 2009, since communication is there from 2007 itself, but ultimately it was forwarded in 2015, then again returned back.
Why was it sent on 2015? That's the question. Why the department delayed for 8 years, requiring an exemption under 05?
Because there is a medical certificate was required.
Where are the reasons for the delay?
33 and 34 medical certificate. So
30?
after medical certificate was received, 33 is the type copy, 34 is the medical.
No, where is the requirement of medical certificate when he was compulsorily retired by orders of the department?
Because he was diagnosed to be mentally unsound.
There is an order of compulsory retirement.
Yes.
It's not voluntary retirement.
No.
There's an order of compulsory retirement.
Compulsory.
So the department wanted him to be on retirement, to send him on compulsory retirement. So they know that he is going away from the department on so and so date. He is entitled to his pension. So it was the bounden duty of the department to forward the papers. Why was it not done?
Yes, that explanation I need to get it.
Who is the officer responsible?
Command, Your Lordship, Assam Special Reserve Force, Karagaon, Kargil.
Where is he in service or is retired?
That I have to find out, Your Lordship, because at that relevant point of time, who was there as the commander?
Now, under what circumstances do you want this exemption on 205?
Because of the delay, Your Lordship.
The
AG
delay has occurred at the hands of the department, not at the hands of the petitioner.
I understand, but
Then
that-
why this 205 is necessary?
Your Lordship, we sent the proposal, but then AG.
Yes, AG.
We raised the dispute, that was when there is a delay of more than 7 years, that has to be required, that's why.
Relaxation is to be
That's a-
given when there is
That's a formality, Lordship, provision of
No.
legal
Why-
provision, Lordship.
Why do you say it is a formality? It's a part of the rules.
Part of the-
Yes, not a
And
formality.
that has to be complied.
So that has
that
to
has
be
to be
complied in for whom? By whom?
That the continuation has to be done from the government.
For delay occurring at whose end?
That is not clear, Lordship.
That is clear. 205 is not a condonation required for the government. It is where there is, for the fault of the petitioner, the pensioner, some documents were not furnished, there was a delay. It is possible that he may not be interested in pension.
Okay.
So after 7-8 years, when he applies for pension, you ask him why the delay. Now the delay is apparent on the face of the record, is on account of the government. Where is the question of asking for 205?
That has come from the administrative, this is parent department, Lordship. We can only act after we receive that.
Yes.
continuation.
Who's the person responsible in the administrative department? We want an explanation. More particularly in the face of the recent
Why the delay?
circular. That
Yes.
persons responsible for delay, they will have to pay it through their salary.
Lordship may observe it and I'll get the inspection.
No instructions. We want him. Get him before the court. Let us understand what is going on for 8 years. Why the pension is held up? Who is the authority?
Commandant 30th Assam Police Battalion,
Yes, call him.
Karagaon, Kargil.
Call him. If the repeated 2023 matter, 2007 he retires, 2015 you send the papers, 23 he files the writ petition, 26 you say instructions are forthcoming. What is going on?
No, that's not why the delay. That was never raised.
Hmm?
That query was never raised by Lordship. That's why.
Is it necessary to be raised?
Now,
We can understand your clients don't read. At least the lawyer is expected to read the rule and tell us why 205 condonation is necessary. Why? When the delay is on account of the government?
Lordship, from page 26 and 27, Lordship, appear that he has been asked twice, Lordship, to appear and submit some requirements, Lordship. That photographs, death certificate or age certificate. Itself, they have annexed the writ petitions.
Where is your explanation in your affidavit? Where is that explanation? Why that affidavit is not here on record?
We filed affidavit and we have 2 and 5.
Who is 2 and 5?
The say Director General of Civil Civil Defense.
Yes, what is the explanation given here?
Explanation we have stated from page number 52 itself.
Hmm.
Lordship, at page number 44 and paragraph number 5.
Yes, read it.
The petitioner Punanda Kaur was sent on compulsory retirement with effect from 31/8/2007 by office order dated due to his psychiatric disorder. Accordingly, he was asked to submit pensionary papers for preparation of pension proposal on several occasions, while letter dated so and so. But the petitioner submitted the petition in 2014 for sanctioning of leave encashment only, without other related documents. Subsequently, the petitioner formally submitted his pension papers on 21/9/2015. And accordingly, his pension proposal was submitted on 2019-12-2016. That's the explanation, Your Lordship. We have been asking him. But
Yes, Mr.
he
Muzumdar,
submitted late. That's what.
there was a delay.
Lordship delay on the part of their part, Lordship, but he was psychotic on psychotic disorder, Lordship, for which Lordship, but he could not respond to the letter, Lordship. But from their part, Lordship, after filing the writ petition, they allowed provisional pension. And Lordship, page 57 of their affidavit, Lordship, all the documents, page 57, may I kindly page it, Lordship.
Yes.
Is a submission of pension proposal in respect so and so. 9/12/2016, all the documents are submitted, Lordship.
When are the papers sent to the office of the governor?
We had forwarded his pension proposal on 9/12/2016.
No, no.
Government. Your
No,
Lordship.
No, you are
Governor.
seeking a condonation under
Governor.
205.
Yes, Your Lordship, in the instructions, Your Lordship, that date is not mentioned, but
When?
they have just stated there that we have after carrying out the required rectification, the pension proposal along with service book and other relevant documents are submitted to the department for relaxation. The matter is currently under process for obtaining special orders of the Honorable Governor in terms of Rule 206 of the Assam Pension Rules 1969. So that
206.
date is not mentioned. In fact, I don't remember the exact order which fell from your lordship on previous occasion. The petitioner was actually asked to submit an explanation as to the delay in submitting the pension papers.
Accordingly, I submitted
That's
same by filing an affidavit
That-
along with the certificate of that.
So-
And the honorable court was pleased to.
He explained the
ask them
delay in his
to-
own affidavit. There was a delay on his part also, Your Lordship, submitting the paper.
On 27/4/2026, this honorable court was pleased to ask them to complete the process, Lordship.
Where is annexure
Now
3
he
here?
is getting the provisional pension, Your Lordship. So, as per order dated 11/3, Your Lordship, 2026. Last order. Last between. Yes.
Have you seen your letter of 31st of July? In the bunch of papers you enclosed, annexure 3.
Affidavit, Your Lordship.
No, in this bunch of papers you handed.
31st of July, Your Lordship. Yeah, yeah.
31st July
Of Your Lordship.
2019.
Yes, Your Lordship.
This is not a case for sending for relaxation.
2019, Your Lordship.
Yes.
After that, Your Lordship.
No, you read the covering letter, last paragraph. Pension proposal was submitted to the department for relaxation under Rule 206, 205. Copies placed at Annexure 3.
Lordship may also peruse for affidavit, Your Lordship.
There is no correlation. That's what we are trying to tell you.
In an affidavit, Your Lordship.
In your affidavit, it was submitted.
This letter is on page 68.
Hmm.
Page 69, page number 69, 7 September. The Director General again writes the Aegis letter dated 9/4 for your for consideration. We have annexed the Aegis letter also. Therein we have again in 2023, Your Lordship, we have again written to the department, the Director General, regarding relaxation. So therein we have written at page number 70 in 2023, 7th August, requesting the government to pass a special order for relaxation in terms of Rule 205 and read with 206. Now, thereafter again, they page number 71, the department writes back to the director asking for furnishing adequate justification wherein delay of submission of pension paper is sufficiently explained. Therein, in reply to that, we again explain, Your Lordship, at page number 72, the explanation as to why the delay occurred, Lordship. Thereafter, this was in 2023.
You are representing whom? The Home Department also.
Home Department.
Hmm?
So we have been pursuing it. Everybody has
No,
been
but
pursuing
Home
it.
Department is not, is sitting over the matter.
So of course, this instruction doesn't say as to when this proposal was placed before the governor.
Last occasion on 27/4/2026, Lordship, order of this honorable court, they also informed that there is under process. On 27/4/2026. 7/4/2026, Lordship. After filing my clarification before the government.
The petitioner before this court is aggrieved that his regular pension has not been sanctioned, notwithstanding the petitioner being compulsorily retired in the year 2007. Stop. Petitioner submits that he was suffering from some psychiatric disorder, and therefore, after he recovered, he submitted all the particulars before the competent authority for finalizing his pensionary papers in the year 2015. So, since there was a delay more than 8 years in releasing, in forwarding the pension proposal to the Accountant General, objections were raised by the Accountant General that unless the sanction under Rule 205, 206 is obtained, pension cannot be processed. So, accordingly, the parent department sought for the relevant reasons as to why the delay had occurred. Stop. Administrative department, on the other hand, submitted all the relevant documents. From the pleadings, it is seen that as far back as 1st of August 2023, the proposal was submitted by the administrative department of the Director General of Civil Defence and Commandant General of the Home Guards to the Department of Home, within bracket capital B. So, thereafter, communications were received from the Department of Home regarding the reasons for the delay in submission of papers, which was again furnished on 29th of August 2023. Stop. Thereafter, the matter has been pending before Department of Home. Stop. By earlier orders of the court, it was directed that the status of the pension proposal of the writ petitioner be communicated to the court. Stop. Today, when the matter is called up, Mr. D. Bora has submitted before the court the relevant documents to relevant communications to submit that the matter is under process. Stop. However, since the last communication dated 2023, last communication dated 29/8/2023, whereby the reasons for the delay were submitted to the Department of Home and Political. No subsequent orders have been, any subsequent communication received? No subsequent communication has been received by the project before the court, before the department, status of the pension proposal. So, it is to be noted that the petitioner is in receipt of provisional pension, receiving provisional pension. In the meantime, so under such circumstances, this court directs the Commissioner, Secretary, Department of Home, in bracket B, Government of Assam.
Perhaps my learned friend, correct Lordship, page 84, 85 of my, in the 85 Lordship, one letter to submit all this explanation, page 85 may kindly peruse. Lordship, it was issued on 27/10/2025 by the Additional Secretary to the Government of Assam Home and Political Department, page 85, which I filed in my additional affidavit.
After that, where is your reply?
I submitted the same Lordship. All the
When?
gap for which the Honorable Court has passed an order on 27/4/2026.
The Department of Home will apprise the court the next day the exact status of the process of the pension proposal of the writ petitioner. Stop. and the steps undertaken to process the pension proposal by adhering to the procedure prescribed under Rule 205 Regulation 6 of the pension, some services pension rules. List again, the month of August.
Any date is subject to convenience.
You are getting a provisional pension. You are also merely answering to the queries raised. You have submitted, but you don't know when.
Because you have
You submitted only after
Medically
11/3/26 order.
It is still unstable.
now lordship, now as per records of the certificate lordship.
It will be listed on a date to be fixed by the registry.
May please, Your Lordship. This writ petition has been filed for non-compliance of the order dated 23rd of April 2015. It's more than 11 years.
This is elementary education matter.
Yes,
Why is it before this bench?
because the social welfare department is nodal department, my lord, by appointment. Because the person is physically handicapped person. The order for appointment was made on 23rd of April 2015. So thereafter, they are not complying it. So as there was no scope for contempt, so we have referred this writ petition. And in this writ petition, by order dated 4/2/2026, it is clarified, my lord.
So some action has been taken.
Lordship.
So when is the effective order being passed? Likely to be passed?
4 weeks, Lordship, post the matter after vacation. Lordship.
My lord, it's ranging from
Because-
2015, my lord. On every occasion, they will come up in new plea, my lord. Now he is asking for 4 weeks. It was specifically directed to complete the appointment within April 10th, my lord. The lady is a physically disabled person, my lord. So she has been running pillar to post this 11 years, my lord.
There is a reference of some other writ petitions.
Lordship, I kindly query the second page of that instruction, Lordship, the last paragraph.
Yes.
It is pertinent to mention here that the Director of Elementary Education was not responding in both the petitions.
Which writ petitions?
That my learned friend is referring to, that 2014 or 15 order. In both the petitions, the Director of Elementary Education was not the party.
1424.
1424 and Lordship, the another one is
So may not-
399 for
So may
2011.
not be. Therefore, it is clarified in a second writ petition, my lord.
Therefore, now the process is taking its course, Lordship.
Third, the counsel for the parties in deference to the earlier order dated 2/6/2026, the Standing Council for Elementary Education, Mr. P. N. Sharma, has submitted before the court the instructions received from the department. He submits that on the basis of instructions received, that the following steps have been taken. Beginning 1, 2, 3, 4, 5. Stop. It is stated that the department is seized of the matter and is taking all steps to comply with the directions passed by the court. However, he submits that further time is sought for. He accordingly submits that the matter be posted again after 4 weeks. Copy of this instruction is placed before the court, which is placed before the court, is kept in the court. Just after 4 weeks.
Okay. So the date may be fixed.
29th July.
That's okay.
MS for which department? Social justice.
Social
Social
justice and
justice.
empowerment.
Social justice and
And
empowerment.
empowerment.
My lord, the matter will pass over the time being, my lord. Senior counsel, my lord, 10 supervision, Lakes, my lord, number 10.
What are these matters?
My lord, my lord, my lord, withdraw the benefits of, my lord, the GOP accommodation, the last place of posting.
Withdraw the benefit of
Yeah, the GOP accommodation, my lord. The
what
last
accommodation?
GOP accommodation, quarter.
Oh.
My lord, where, my lord, the petitioners, my lord, are posted in the northeastern region. My lord, the time to time, my lord, the respondent number 2, my lord, the Director of State, my lord, the Minister of Housing and Urban Affairs, my lord, issued, my lord, the notification, the officers, my lord, who are posted, my lord, the northeastern region for 3 years. So, my lord, suddenly, my lord, the respondent number 2 issued the, my lord, improved notification on 6th of October 2022, my lord, with a retention period up to, my lord, 31st March 2022. So, being agreed, my lord, the petitioner approached before the honorable court, my lord, and these honorable court, my lord, on 29/3, my lord, 2023, granting my lord interim protection for my lord not to coercive action. So, my lord, the last occasion, my lord, the honorable court for instruction.
I have got the instructions. It was pursuant to a communication by the Ministry of Home Affairs, to Ministry of Non-Affairs regarding regularization, but right now that will not be very important because we are on the issue whether they can retain the quarters accommodation beyond 3 years.
Where is that impugned order? What impugned orders are you challenging?
Matter time being, my lord.
Trying to understand this matter, you are the counsel on record.
In order, my lord,
Yes.
my lord, 104.
104 in
104.
My lord, the item number 10, my lord.
Item number 10.
925.
10. Yes.
My lord, the subject, my lord, review of incentive allowance.
Page number, page number.
Page number, my lord, 104.
104.
Of incentive allowances granted to AIS, All India Service and Central Government Group of Service. The relevant, my lord, paragraph 3 and 4, my lord. Clause 3 and 4.
3 and 4.
As per clause
What is the benefit given that you are given the Northeast and Sikkim?
if they are posted here, they can retain the quarters in Delhi for a period of 3 years as per
Okay.
the rules. Now, with the change of policy, Lordship, now the Northeast, they can, Lordship, the policy of retaining it for 3 years is already there. Now they are occupying it for more than 3 years. And as such, this new notification has come by which they have to
They are
vacate
still
it.
entitled to retain for 3 years,
They are still entitled to retain for 3 years.
not
And-
beyond that.
Not beyond that, as per the rules. And even in this petition, Lordship, the prayer was that they want to stay till 36/2024. Now we are in 2026, Lordship.
Yes.
By virtue of the prayer made, this petition by itself is infructuous. Their prayer is for allowing them to stay till 36/2024.
Thirty-six, 20.
Yes, page 31.
Yes, my lord, there was a notification, my lord, we have, my lord, before date, my lord, page 102, my lord, where my lord notification was issued, my lord, on 8 April 2021, that the last date was 36, 2020. So there was a notification, my lord.
Yes.
But my lord, suddenly, my lord, they issued, my lord, this notification.
So that is all right.
My lord,
But
one
now,
thing, my lord, now, my lord,
with the efflux of time,
authority, my lord, calculated the, my lord, the penalty, my lord.
yes,
This, my lord, there is an interim order by this, passed by the Honorable
yes,
Court. So we are on, my lord, rule 43, yes, my lord, there is a 3 years, my lord. More than 3 years, my lord, we also, my lord, agree, my lord.
so,
But, my lord, they calculate our penalty, my lord. We have, my lord, my destination, I have made a power prayer, no penalty. But they have calculated, my lord, more than one course, my lord. Like, my lord, the telescopic method, my lord, it's a compound interest.
that will again be as per the rules.
And even, my lord, my whole prayer, my lord, my matter may pass out time being, my lord, to sit down to the take, my lord. That's true, my lord.
Ashok, let it be on the Tuesday election. I have got some other things, so let it be on
Tuesday.
Tuesday election.
We are passing it over for the time being.
Lordship, should be fine.
Pass it over for the time being. You ask your colleague to be there. Give you accommodation,
Yes.
not an issue.
Lordship.
Obliged.
Yes.
So they have filed the affidavit lodged, there is in opposition. Affidavit in opposition file lodged. I have to file reply lodged.
What are these matters?
After lordship in 2023, a recruitment notice was issued for appointment of constable lordship. Then prisoner lordship pursuant to that notification applied, and we have been qualified in both the test, PST and PET lordship. And our case is that we have applied under the EWS category, and we have scored more marks, cut-off marks, than the last candidate secured by the other EWS candidate for BSF, CRPF, and ITBP. Now, the authority has filed affidavit saying that the EWS certificate was not produced by the candidate at the time of document verification. But our case is that while we have applied through online application, at that relevant point of time, we have mentioned about this certificate and produced also. We procured that certificate prior to this advertisement. That we have annex also. And thereafter we approached the authority also in terms of the guideline. And that representation also not disposed of.
So these matters, we had disposed of certain matters that
This was,
that
that was
cut off
NCL,
date.
NCL matters,
Oh,
non-criminal.
NCL. This is
NCL.
EWS.
EWS.
What is the stand of the state?
Lordship, our stand is that at that relevant point of time, document verification, now they are producing the documents, but at that point of time, they have not produced. They have produced the document. If Lordship takes in 183,
Yes, 182.
183 in my affidavit, Lordship, kindly see any page number 110. This certificate they have produced, Lordship. Written 10. this was valid for the year 24-25. We required 23-24. And the for financial year 23-24, it should be 22-23. Subsequently, in the writ petition, they are producing the annexing that 23-24 certificate is there, but at that relevant point of document verification time, they have never produced that certificate.
So subsequently they have obtained.
They have obtained earlier, they have this certificate, but at that point of relevant point of time, they have not produced that certificate. They have given.
Why was it not produced?
So Lordship, we have mentioned, Lordship, we have submitted. Lordship, there are some important dates, Lordship, that may be Lordship record, Lordship. The certificate.
Where in your writ petition have you enclosed this document?
It also annexure 4 page 65.
65.
This is the certificate 18/6/2023. This was the date of issuance of the EWS certificate, and I have
No, these
possessed
are
this
two different
certificate.
dates.
Lordship,
Different dates.
These are two different dates.
No, there are two, so for 2 years also there are two different EWS certificate. One is for 2023, 2024.
You
And next
are
one-
seeking employment for this year,
Yes.
Yes.
23-24.
Yes. And this certificate, even prior to this notice, Lordship, we have procured.
Is there any record of the papers which are produced before the authorities?
Yes.
And Lordship,
There
kindly
is?
see,
Yes.
page
Because
52
kindly
clause-
see Lordship page
clause-
110. 110 which they have produced, there is a seal of our who have conducted in the rally, what they have produced. But in that
Where is that seal?
Lordship, page 110,
Below the signature.
yes. The JC,
No, but this is the circle officer.
no Lordship, thereafter Lordship, 110 Lordship.
JC.
JC3 Nayak Subedar Clerk,
No.
RP Singh. This is the document they have produced at that time of document verification. They've given opportunity to produce that document if they have, but they have not produced. Now they in the writ petition they
That
are
were denied, Lordship. They have not taken any communication to us, not even any mail. Simply merely stating that we have been given time to produce the certificate.
clarified.
That I kept together file. No, in other cases, I have filed affidavit. And other way also, page 52 as per clause 11. At the time of application, the candidate should mention to which category he belongs. Otherwise, the candidate will be cancelled. So since I procured the certificate in June 2023, therefore I have applied under the EWS category. Let's say kindly move for a moment here, page 52 clause 11. How to apply, Lordship? This is the online application form. Clause 11, Lordship, see. May I read, Lordship?
52.
Page 52 in the first aid petition 1823. If you belong to SC, ST, OBC category and have
No,
migrated,
this 52 is a list.
no, in the read petition 1823, page 52,
1823, page number 52.
Lordship, this is
Is a
the,
part of the online form,
Yes.
application form.
the notice.
Yes. Then
So
serial
this is the-
number
Serial number 11.
11.
If you belong to SC, ST, OBC category and have migrated from the state or union territory of your origin to another state, you have the option to either avail the benefit of reservation from the state UT of your origin or be considered as unreserved or EWS candidates against the vacancies of the state or UT of your present domicile. Make your considered decision and fill up information in the column accordingly. So since I have procured this certificate on June 2023, advertisement issued on November 2023, therefore I have applied. Now the authority is saying that
Do you have the records of the?
I have to check it up, Lordship, but because we don't deny that he doesn't have the certificate, but he
Is not
at that
produced.
not produced. He produced different certificate.
But he says it was produced.
But you,
Not
because
produced.
while we apply to online, then we have to mention about the date and the
Then
category.
why you have produced this 24 certificate then?
So far, my case is concerned, I have produced both the certificate because 2023 as well as 2024. Now they have denied, and also kindly see their status. is qualified. Lordship, we see for a moment. Page 113. The affidavit. Even after document verification, they are saying that the final status is I'm qualified. Page 113. This is the Lordship, their online data verification sheet. Page 113, clause 6.6, 6.7, DME, that is detailed medical examination final status, qualified. And departmental status, Lordship, physical position, qualified. 5.1.
However, we have never denied this.
And if other also, Lordship, we have, there is the admitted fact that we have procured this certificate at the relevant point of
So you
time.
may have procured, but the
But you have
dispute is whether you produced it
So
or
from
not.
my case is concerned, since I have the certificate, that is why I apply and I produce this certificate to 2023 as well as.
Then why did you not? These markings at page number 110. Is 110. The endorsement of the department, Mr. Roy.
Lordship.
This is done on the original certificate.
Lordship, I think which this certificate they produce, on that we have.
Record.
Lordship.
What we want to know is that if you had produced two certificates, why there was endorsement on one and no endorsement on the other?
Record.
Huh?
That record, the relevant record is produced.
You produce the record, at least so far as these matters are concerned, individually. Then you want to file a rejoinder
Yes, Lord.
in this matter.
Yes.
All the matters are same, Lordship.
In otherwise, Lordship, I have filed
Only
rejoined
one-
there, Lordship.
One case.
Yes,
they have
then
filed.
is same. We have
Right.
not produced the irregular certificate for the relevant period of time and they have
According to
extended our
the-
time.
Dispute in the present proceeding is the claim made by the petitioner that WS certificate year 23-24 is by the petitioner in bracket
Annexure 4, Lordship. Yes,
annexure 4, page 65
65.
was not accepted, and accordingly his candidature rejected. So, these respondents have filed their counter where what they report they have enclosed the EWS EWS certificate of 23-24 dated 17/6/23. Petitioner claim was not accepted. The respondents have filed their affidavit and have included certificate dated 7/6/2004.
24.
24.
Page 66.
24. No, 110.
Or in, Lordship.
7/6/24,
7 says, in my report also I have enclosed.
which, according to the respondents, was the certificate which was produced, but it was valid for the year 24-25. So, the certificate required to be valid for the year. Mr. S.S. Roy, learned CDC, has a record certificate enclosed. Submit that on the verification, it was duly endorsed by the concerned officer who was responsible for examining the documents. And it is clear that the document which was produced by the petitioner, not the EWS certificate for the year 2023 is claimed, but the EWS certificate valid for the year 24-25 is enclosed as a photocopy are the affidavit filed with the respondents. Considering the dispute between the parties, this court is of the view that the relevant records would be necessary to examine the documents available to the department. So, let this matter be listed again.
Sir, it is
6th of August, by which date the respondents will produce the relevant documents. Stop. The petitioner also seeks liberty to file counter affidavit, where mate is also allowed. Matters be treated to be part of.
Right.
6th of August.
Item number 39, some of the petitioner, there are 9 petitioners, some of the petitioner got job.
Petition
They
number
want to
1,
split.
2, 5 and 7.
39. They don't want to press.
Not
There
petition
are other
number 1, 2
petitioners
and 5 and 7.
Yes.
Petition number 1, 2, 5 and 7.
Petitioner number 1.
Establishment permit,
Petitioner number 1.
1,
Huh?
2, 5 and 7.
5 and 7. They've got jobs.
Yes.
They don't want to press. Item number 39, counsel to the petitioner submits that petitioners 1, 2, 5 and 7, namely Namgeta Giri. Your petitioners in the writ petition during the pendency of the writ petition have secured employment as what?
CISF council.
As under the
The
CISF.
CISF,
Therefore, they are disinclined to. They do not want to press the writ petition. They present for. So, counsel for the petitioner, liberty of the court, have the names of petitioner 1, 5 and 7 being deleted from the writ petition. There are the learned CGC, Mr. S.S. Roy, and Mr. P. Surya appearing state. You're appearing for?
I'm appearing for the statement.
There is no state here.
Is there.
Is it?
13. Amended.
Huh?
There, state.
State is there.
There.
Submits. There is not object to be prayer made and submits that petitioner 1, 2, 5 and 7 have indeed secured their employment independently of the writ petition. Accordingly, the writ petition will now proceed in respect to the claims made by petitioners 3, 4, 6, 8, 9 and 10. Released again along with so.
My case is similar with the item number 38.
Lordship.
Relevant record may kindly call for your lordship
We have
in connection with
relevant
this
records we
certificate.
call for in the matter listed on 8th of August. 6th of August.
6th of
6th of August.
Obliged.
Not to be taking this matter after some time.
After some time.
Gotcha.
Right after some time. Yeah.
Follow. May it please the Lordship. My lord, here the case is the petitioner was appointed as a constable in the CISF. My lord, he was sent for on duty in New Delhi. He was appointed in the airports. He was sent to Indira Gandhi International Airport, New Delhi. There, while on service, he was terminated, saying that though you have given a certificate showing that the place where you stay in Silchar, you are not residing there. So you have given a false statement, you are out. The rule provides, my lord, if there is no reason shown, then simplicity termination can be given. But if there is a reason, there should be a procedure. They have given a reason and they have not gone through the procedure.
My lord, your lordship may look into their affidavit I am placing, my lord, all the documents they have annexed. My lord, the affidavit filed by Ravish Kumar Singh, who is the, my lord, duty as commandant CIS. My lord, my appointment order is at page 98.
Yes.
Where it says, my lord, that recruitment of constable Central Industrial Security Force offer of appointment is given. And my lord, what they have stated, my lord, that is the state of Assam, because no domicile certificates are issued. Here in page 99, clause 14. Page 99, clause 14. My recruitment order. The vacancies are distributed among the state according to the
Clause 14.
14, clause 14.
Yes.
Roman 14.
Yes.
The vacancies are distributed among the states according to their population ratio. Domicile of the particular state are eligible for appointment against the vacancies allotted to that particular state. Your appointment is provisional, is subject to status of domicile or domicile certificate being verified. If the verification reveals that the claim is being to that particular state against whose vacancies your selection has been made is false, the services will be terminated forthwith without assigning any further reason, without prejudice to such further action as may be taken under the provision of Indian Penal Code. This is one of the clause they have issued.
What relevance has it?
Because I am saying, because my termination order at page 103, clause number 2.
Yes.
And whereas during physical verification of residential status, the additional magistrate such and such dated as initiated the such and such the petitioner is not residing in village such and such the district of Pachar, Assam. So on that ground, I am being terminated. And the rule provides, my lord, you also will find that is that page. Against that, I went for an appeal also, my lord, and at page 112, the appeal was upheld. Against my termination order, the appeal was upheld. And my lord, the rule, but as they have stated in their affidavit.
Where is that rule? Where you say the reasons are to be given? Where is that?
My lord, I am giving that. Seeing that rule that is starts at page 101. Page 102, number 4. During the period of probation or its extension time thereof, as the case may be, the appointing authority may, without assigning any reason, terminate the service of a member of the. Then they have said, on the ground of furnishing false or incorrect information at the time of appointment of that member of the force or for his failure to pass the basic training such. The reasons my statement is this, my lord, as the case may be, the appointing authority may, without assigning any reason, simply say they may terminate it. But the moment they have said that I have given a false document and I have annexed all my Aadhaar card, PAN card, everything in my read petition, your lordship may turn to page.
No, is it your case that you still continue to reside in that address?
Not my
furnished.
But I am there.
You're still there.
I am there. I have a land document. I have my PAN card, my Aadhaar card, everything is there. I am from that Silchar area. And this is what my lord.
The issue is not whether you are from the district or the city or the town.
No.
The issue is whether that exact address which you have given in your papers, you still reside there.
My lord, I still, because I was during that time, I was sent on transfer for work in New Delhi. During that time, they made a verification when I was not present. It is an admitted fact. I was working in Delhi, Indira Gandhi International Airport, my lord.
What is that address you have given?
My lord, your lordship may look into my documents. That are, it starts at page 32 of my read petition. Bottom, my lord, the address is given in my election card. Then, my lord, next page, page 33. Aadhaar. Then, my lord, page 33, the election. And my lord, they have annexed one physical verification report in their affidavit. That is at page. Behind my back, they have made a physical verification at page 97. And my lord, on March,
97.
there is a report by the circle officer in March 2026 that I am still residing over.
'97.
Page 97, my lord.
What is your name?
My lord, Rohit Kumar,
Serial
Rohit
number?
Kumar Yadav. Middle portion is there. Number serial number 9.
9.
Is not residing, last line is not residing in the above address as per report submitted by the superintendent of police, such and such. During that time, my lord, I was there in the international airport in Delhi.
What is the stand of the respondents? How have you caused the verification?
Verification, Lordship, basically, Lordship,
You've asked the
Yes.
OC to give a report.
no, we have approached the ADC, Lordship, to do a physical verification of the residential address of the some persons, Lordship. One of them is this Rohit Kumar Yadav. And after that, Lordship, page number 97, where it has been stated, Lordship, from the middle. Point number 9 is Rohit Kumar Yadav. So, PS Silsor. And there, along with him, Lordship, there are 13 other 40 number people of other district of Assam, Lordship, where it has been stated that is not residing of the above address as per
Where is the address which you had given in the application form?
My application form.
Is it here somewhere?
My lord, your lordship will find at page 98 my recruitment order where my address is given.
This was sent by post.
By post. By the CIS. Top, bottom, my lord. Top. This was my recruitment order. And my termination order, my lord, at page 103 in New Delhi Airport.
Yes.
Lordship, the rules of termination, Lordship. I think Lordship already gone through page 102, Lordship. Please, Lordship, section 26, subsection 4. During the period of probation, he was in the period of probation, or his extension thereof, as the case may be, the appointing authority may, without assigning any reason, okay, Lordship, terminate the service of a member of the force on the grounds of furnishing false or incorrect information at the time of appointment of that member of the force, or for his failure to pass the basic training, or repeated course by tendering a notice of 1 month with a defect, or 1 month's pay in lieu thereof.
Are you enclosing any certificate of the circle officer?
No,
or
my lord,
any
this in between, my lord, there was an, because they were asking for an inquiry, so I applied to the circle officer about my receiving status, and this last application, my lord, by a circle officer who made a report and said that I am staying. 19/3/2026.
Only the report. Where is the report? So forwarding to the report.
Well,
Where is the report?
what I have.
This you have not brought in before the authority or in the present.
No, but now it is recent. The petition is of 2025. It's of 2026.
I think my sister was
Anything to submit?
correct.
Same circle officials reporting.
It's confirmed. He's a resident.
Acted upon the report of the circle official.
No, you acted upon the report of the SP, I think, no, ADC. Then why this report was given? Wrong report?
That lordship.
At that time, he is not available in that state address.
Huh?
Actually, lordship, at that time, I think he was not available in the address, lordship.
Obviously, because he was posted outside.
Yes, lordship.
Case number 94, lordship. This is directly not in connection with this Rohit Kumar Yadav. Otherwise, lordship, there is a presumption, lordship. Case number 94, at para number 3, lordship.
Yes.
The matter examined at SSC headquarters, and it was observed that these candidates have passed their matriculation exam from one state but have provided domicile certificates of another state, Italy, West Bengal, Assam, Nagaland, for initial.
These are not applicable here. This is not a case for term. This is not the ground on which they are terminated. His termination is that he is not there in the address. The same office is now saying that yes, he is a permanent.
And one more thing, allegation is that he has submitted false.
That's what. So the address which was submitted with the papers was not found there.
It's not
Therefore,
found.
it is
He is not
false.
physically found there.
Yeah, but this is contra information coming from the same office of the ADC. Heard Mr. P.K. Roy Chaudhary, Ladakh Senior Counsel, assisted by Mr. Funchal, Sri Burman, State Counsel, and Mr. C.K.S. Burwal and CBC. Petitioner had applied for and was selected for appointment in the CISF.
CIS, the Central Industrial Security Force.
On which date?
My lord, appointed on 11/11/2020.
11/11/2020. So he was placed on probation for 2 years. And during his probation, near his services, he was posted at the Indira Gandhi International Airport, New Delhi. He submitted that view of his posting, he was required to reside in Delhi. So he is a permanent reclaim, according to the petitioner, he is a permanent resident. The address mentioned in the course title, and which is the same address which was furnished along with his appointment, along with the papers filed during the process of selection. So, the Learned Counsel for the petitioner submits that where is the appointment order?
The appointment order is at page, the affidavit your lordship is there. Page 98, man.
Petitioner was issued the appointment order by post, and it is clearly reflected in the appointment order, the address of the writ petitioner. So, thereafter, the CISF authorities conducted a verification through the State Department, and perhaps because the writ petitioner was posted in Delhi at the relevant point in time during his probation and was not available at the address which the petitioner has placed, particulars of which the petitioner has placed before the department. The report was issued by the Additional Deputy Commissioner Achar Silchar by communication dated 2nd of August 2024. The Deputy Commandant regarding the verification of residential status of the candidates. Verification was sought for by the CISL authorities. So, serial number 9, named the petitioner appears. As many as 14 candidates, as many as the residential status of as many as 14 candidates was verified, and as per the said communication, it was found that these candidates are not residing in the above address as per the report submitted by the Superintendent of Police within bracket DSB bracket close Kachar Silchar by his communication number so and so dated 24/7/2024, page number 97. Pursuant thereto, the petitioner was terminated from service by the Supreme Order 103. Dated 4/10/2024. It is submitted that in the said order, the ground for termination was that during physical verification of residential address, the additional district magistrate, District Kachar, by communication dated 2/8/2024, intimated that the writ petitioner is not residing at the address shown, namely page number 103, address to other village so and so so and so. It is submitted by the council for the petition that it is still his address, and he resides in the said address. His appointment orders were sent in the said address, as also his.
I preferred an appeal, that is there. Appeal was there at page 10.
However, the termination order was sent to the petitioner while he was serving CISL. So it is submitted that perhaps during the verification, the petitioner was found, as he was listed in the international airport in Delhi, that the revenue authority had returned a finding that petition was not available. So being agreed by the order of termination, Inspector General CISF in Delhi by said appeal came to be dismissed by order dated
13/1, my lord,
13/1/2025. So Learned Senior Counsel therefore submits that this termination of the writ petitioner on the purported ground of service furnishing false information regarding the address is totally incorrect. Proper verification ought to have been made, which was not done. The CISF authorities merely relied on a report submitted by the revenue authority during the time when the petitioner was not available at the address, at his address, and was admittedly rendering service in his place of posting, which is an international airport in Delhi. He therefore submits that the termination has also been set aside and the petition will be directed to be reinstated in service with back wages, service benefits. Mr. CKS Burwa, CBC. The contention raised by the petition submits that the department has filed their affidavit where they have referred to the report by the state affidavit submits that once the revenue authorities have given a report that petitioner be a resident of the address submitted by the petitioner, there will be occasion for the CISF authority to disbelieve the report given. Accordingly, petitioner is terminated. He referred to the where are the rules, page number?
Page number 102, Lordship.
He submits that under the CISF 2001, under 26 within bracket 4, candidate may be terminated. Provision during probation or extension thereof on furnishing of false or incorrect information at the time of appointment, that member of the force. So, he therefore submits that on the basis of the report issued by the additional district magistrate, Achar, that the petitioner was not a resident of the address, it amounted for furnishing of false and incorrect information by the petitioner regarding his address at the time of appointment, therefore invoking 26(4), the petitioner State Council appearing state respondent. State is a party here. Respondents 5 and 6 submits that on instructions that subsequently there was a report. Was there a direction by the court? Reconduct. Verification.
I think yes, Lordship.
Very good. By order dated 3/2/2026, verification is directed to be issued by the done and undertaken by the department. So, in deference to the said order, verification will be undertaken. The report. See. Circle officer, on the basis of the report received from the circle officer, the additional district commissioner of Kachar has communicated communication dated 0/6 that the petitioner is a permanent resident of the address mentioned and it is residing there in his own house. This communication is placed before the this communication. So, perusal of the communications placed today. Sport. That the petitioner's appointment as a CISF constable on probation was terminated. The ground that he had furnished false information and thereby invoking 26(4), the petitioner is terminated. Service. So, his appeal against the termination order was dismissed. Stop being agreed with the affidavit filed by the CISF authorities reflect that verification, physical verification was undertaken state authorities and the requisition made by the CISF authorities. So the state authorities have submitted a report, CISF authority, that the petitioner along with by communication detail second August 24, the writ petitioner along with 13 other candidates found to be not residing in the addresses as per the report submitted by the Superintendent of Police, the bracket DS, bracket Kachar, signature by letter number so and so dated 24/7/2020. Readings by the respondent, there is no dispute that there is no denial that the writ petitioner was posted in Gauhati International Airport at the relevant point in time during his period when verification was undertaken. Which are referred to, namely Rule 26(4) reads as under. Plain reading of the rule reflects that a candidate during the period of probation will entail termination from service inter alia. Event of furnishing false or incorrect information. So, therefore, empowers the authority to terminate the member of the force during the period of probation upon the member of the said member of the force furnishing false or incorrect information. Stop. The circle officer dated 2nd August, based on the report of the DSP. The report of DSP ministry reflecting that the petitioner was not a resident of the address reflected in the official address which the petitioner has furnished before the authorities, amounted to furnishing of false and incorrect information, and therefore the petitioner's appointments to terminate. So, has the state filed any affidavit? The state has not filed any affidavit. However, in deference to the earlier order dated 3/2 2026 passed by coordinate bench, the inquiry was undertaken and by communication dated 20th March 2026, furnished to the State Council by the Additional District Commissioner Kachar, it is clear that the petitioner, it is clear that from the report submitted by the circle officer, Sodor Revenue Circle Silchar, it is clear that the petitioner is a permanent resident of the address mentioned and is residing in his own house. such circumstances, it appears that the earlier report filed by the additional district commissioner dated 2nd of August 2000. What was the earlier?
2nd August 2024.
2024. Appears that the report of the additional district commissioner dated 2nd August 2024 and the report now furnished by communication dated 20 March 2026 are in conflict with each other. So there is no explanation as to how the earlier report dated 2nd of August 2022 came to be issued, the manner in which the inquiry was conducted.
Earlier report is given by the superintendent of police. On the basis of that report.
The earlier report was issued by the additional district commissioner on the basis of the report given by the superintendent.
SP Kasai.
SP Kachar. The report of the SP Kachar is not before the court. Nevertheless, deference to the earlier order passed by this court dated first by the coordinate bench dated 3/2/2026. The fresh inquiry was conducted by the district authority, and the report has now been submitted before the court, which reveals that the petitioner is indeed a person and he resides in his own house. So that be so, then the termination order dated so and so, which was based on the earlier report given by the district commissioner, appears to be correct information, and as a consequence thereof, it does not satisfy the rigors of 26(4). It cannot be terminated. It cannot be, in view of the present report, additional district commissioner cannot be said that the information in respect of the address of the petitioner furnished by the petitioner at the time of appointment, recruitment and appointment amounts to furnishing false or incorrect information. So, that view of the matter, the matter is remanded back to the authority. Please pass this order of termination.
Also, the appointing authority.
Will their appointing authority.
By
Commandant, Chairman.
Commandant CISF. Commandant, page number 104 also.
That is in Delhi.
Appellate order was passed by my lord, Inspector General.
Commandant CISF unit IGI airport, as also the Inspector General CISF, so and so block, Loti Road, New Delhi. Revisit the order of termination dated so and so issued respect to the petitioner. And stop. The authorities directed will take into consideration the subsequent report issued by the additional district commissioner, Kachar, by calling for the relevant records and for proper examination. If the address of the petitioner is found to be correct, in terms of the particular which was furnished at the time of the selection and appointment, then the petitioner, the termination order be recalled and the petitioner be reinstated in service with full service benefits, including the service and pay benefits. In the absence of any communication being forwarded by the state authorities to the CISF authorities, we permit CISF authorities to call for the relevant records from the state authorities in respect of the report given by the additional district commissioner, Kachar Silchar. Stop. Upon such a request received from the CISF authority, the state authority, we forthwith forward all the relevant records to the CISF authorities for passing appropriate orders as directed by this court. Let this entire exercise be undertaken and completed in a period of 60 days from the date of receipt of the certificate copy. Writ petition disposed below. Pending I, if any, stand vacated, interim orders, if any, stand advanced. Yes, PWD.
Lordship, on the last two pages, Lordship, I have prepared a written argument, Lordship, I place it on record.
First you argue, then you
Lordship,
place it.
Yes, Lord. This petitioner, Lordship, he has retired from service on 39/2010. The driver and in the PW department under the establishment of Caribbean Autonomous Council. Now, Lordship, the AG has raised an objection that when I was.
You were working as master of
Boxes.
work charge, driver.
Right.
Then you were brought into some regular
Regular establishment, 2011.
2011.
My lord.
Which the department says is not possible because it was pursuant to a resultant vacancy
Lordship.
of a person who was regularized
Lordship.
by an order where it is reflected that these are supernumerary posts which will go back and no further appointment.
That is an absolutely wrong submission, Lordship. I have obtained instruction, Lordship, that earlier incumbent normally does, he occupied a regular sanction cadre post. And that was not a personal or ex-cadre post. It was, even after his retirement, also the post existed, the department also. I have obtained specific instructions from the officer. I have some proof. Also on 3 documents also I have got also.
You have to bring it on record if it is there to show that this is a regular vacant post. Which
Because
was occupied by the
this
predecessor.
issue was raised by them also. My
No,
case
they are
is
raising
I
it-
am just praying for my.
They are raising it by referring to some order.
But
if
in
I'm
the
not-
affidavit also, they have not said anything against me also. Caribbean Autonomous Council affidavit also, not a single allegation.
We are only asking you if you have these documents, bring it on record. Place it.
I can bring it on record.
If you have these documents, say that to show that this was otherwise a regular post.
Regular post.
Show us the document. Yes, what is this?
Also,
24/4/2007.
he was
What is the name of the person who was the predecessor?
Nolini Das.
Huh?
Nolini Das.
Nolini Das. Nolini Das.
Okay, I've been only one copy of it.
You have given me this. You have the 3 copies.
The non-religious lordship, he was occupying a permanent cadre post lordship in the department. So even after his retirement, that post was there. So it was so that 1999 office memorandum will not apply in my case. It is only in respect of lordship supernumerary post or personal post.
What's the name of the petitioner?
Lordship Mangal Singh from first.
Mr. Dhor, you were supposed to present some documents to show that
My lord,
how the original post was
thing is
filled.
that we missed the case, but there is in item 47, the name of PWD is not shown, standing council, anything, my lord. So we have missed, my lord. And I'm sorry, my lord, I didn't appear in the last occasion. There is in the cause list, my lord, name is not shown.
Yeah, where is Mr. Nayak?
He is, my lord, from
If
morning.
it was in his presence, the matter was fixed. You were not there, but Mr. Nayak was there. He is aware that the matter is fixed.
My lord, we have missed the thing, my lord.
No, how you had missed, I can understand. How Mr. Nayak will miss, it was in his presence that the matter was fixed. All the other councils are present. Why is it that only PWD misses the matters?
No, my lord, name is not shown in the cause list.
What is the purpose of fixing a matter in the presence of council? If it is the cause list which you have to rely on alone, cause list is only a convenience. Names may or may not be reflected.
I apologize, my lord, but what happens, my lord, so many matters gets decided every day, my lord. So we rely upon the cause list, it is there, my lord. I apologize.
Now you tell us that some occasion we remember that there was a submission made that the post which was vacated by the predecessor is a supernumerary post. Therefore, it cannot be filled up. So if it is supernumerary, then the appointment of that predecessor has to be shown that it is supernumerary. And Mr. Sutia, any submission?
In the accountant general filed the affidavit to that extent that was supernumerary position cannot be filled up. I called the executive engineer to get the service book of the nominee just my lord. But last occasion executive came, but I could not get the service book. So I could not also verify whether it is a supernumerary post or is a regular vacant post. If the petitioner furnish certain documents, my lord, by affidavit or to furnish to me also, then I can take the instruction on that.
No. If the service book is available, if you can verify.
My lord. And
Verify.
that AG, my lord, accountant general just told me that the council that the service book originally generally returned back to the department, my lord. So I get the service book, then it will be clarified whether it is supernumerary post or not.
Yes, Mr. Das.
In that case, lordship may fix it, has the lordship for final disposal also.
We don't know whether
I also
service
given
book
a
they'll be
written
able to procure, not procure.
Take time, sir.
Will you be able to do it by Thursday?
But service book, my lord, it is required to be, the old service book is required to be verified. I wrote to them, my lord, they could not get the service book. So I could not verify it, my lord.
It will be available in Karbi Anglong.
Capital Depot, my lord. That service book, before exiting the. It should be there. Service book of Nolini Das one.
Control. Respect of the claims made by the petitioner for his pension,
Pension. Pension and gratuity.
pension and gratuity. His initial appointment made the petitioner, subsequent regularization in a post which is stated to be a permanent post, which became vacant. The superannuation of the predecessor. Once one Nolini Das was employed as a truck driver. Submission of the petition that Nolini Das was brought into the regular cadre in a permanent vacant post and not by way of a supernumerary post created only to accommodate, said Nolini Das. So, there are Mr. R. Bhor. Now we are recording your name. Mr. R. Bhor, learned counsel for the petitioner, standing counsel for the petitioner submits that the claim of the petitioner can be accepted only in the event the petitioner is able to furnish some material suggests that his regularization to the permanent cadre is in a post, sanctioned vacant post, and not in a supernumerary post, which was created for his predecessor, Billy Das. There are Mr. Sutia, learned senior counsel appearing for the Karbi Anglong Autonomous Council, submits that he has already requested the executive engineer, Difu. This is PWD.
To furnish the copy of the service.
Furnish a copy of the service book of late, Nolini Das. To verify as to how the appointment of Nolini Das, how the regularization of Nolini Das. Mr. Sutia submits that the service book ordinarily contain relevant address, giving an indication as to whether it was by way of a permanent sanction post or it is by a supernumerary post. And considering the issues raised, we list this matter again in 30 July 30, by which date the respective council, the standing council, KAC, will apprise the court with regard to the particulars available in the service for Nolini Das.
Under was part also.
We were supposed to place on record the materials based on which in the portal for registration in the employment exchange minor, those requirements of 20 years of stay, and we have my unfriend has written to the department and they are asking for some more time to place that on record. I've informed my unfriend. He has got some urgency in the matter, we know. But then
Lordship has only mentioned in last opinion, more than 2.5 years appointment. And
Well, so agree on a date and tell us.
yeah. Well, what I desire, even on the other issue that original inventor, we were thinking that state should come up with an affidavit. And otherwise, from my side, I cannot give any definition and the interpretation on that. So
I am praying that immediately after the vacation on the reopening, maybe first day or second day, it may be kept so on that it can be disposed. My
Yes.
landfill is completed.
My only request, is Lordship to mention that it is fixed for final disposal. That because it's been more than several occasions they have taken time and 2 affidavits has already been filed. So my
Alright.
humble request, Lordship.
On joint request, matter be listed on the request of the learned additional for the state, matter still different, listed on 16th of July. Attempt will be made to dispose of the writ petition. Mr. K. Chaudhary.
Right. And my another request is Lordship can make it part out because we've never been part.
I think it is
The
part
Lordship
heard.
has heard it on land.
It is part heard, it is part heard.
Lordship has not mentioned it on the.
Then
order.
we'll mention it on 16th.
Anyway.
My lord, I have one submission, item 61 and 62. These two matters are, my lord, very urgent matter for us because they are filling up all the posts usually. So if your lordship may kindly allow us to update the matter today.
All right. Let us, we are touching the hearing, let us see. You are not pressing this matter.
No.
I on I.
Yes, it's there, my
It's already done at council. Has submitted that an IA has been filed by the petitioner seeking withdrawal of the writ petition.
This has come by way of an affidavit, not an IA.
By an affidavit.
My lord, it has come by way of an affidavit.
Says the petition.
I stated it's a
Petition
petition,
under
but
order
registry has recorded it like an affidavit.
So, but what you filed is a petition. File the petition, which is yet to be numbered. Registry will number the same. This petition is filed under order 32-1, read with section 151. 23. 1, section 151, seeking withdrawal of the writ petition. Remain is not objected to by the respondents, accordingly the petition stands dismissed on withdrawal. Removal will stand vacated pending either.
I'm deeply.
Yes.
Lordship, have received one instruction that one board proceeding is there and they have verified and go through all the representation received regarding this summer saving transfer 2026. They had received total 930 applications for retention, etc., or to transfer any other places. And after considering that, they had passed the order, Lordship. There is none other record is regarding that. Whatever is that, the order is there and it was already sent to his WhatsApp number also, and that is
Appendix attached to paper.
There are no reasons recorded. Each case will have to be treated on the
Lordship. But
specific
that
facts.
in the first place, that is written, Lordship, that they have considered those.
But if they've considered, there are no reasons to support that. On what basis they have considered what they have.
Fact, Lordship, this is not something only regarding the daughter's education is there, Lordship. It's not that some very genuine medical etc. grounds were given. His only case is that his daughter is preparing for NEET. Although mother's ailment is there, but he himself has stated that he is not a caregiver. So she is preparing for NEET, and that's my.
This doesn't indicate any application.
In the first page itself, in that it is written that Lordship, that paragraph 3, accordingly his representation stated so and so, again his transfer so and so received through a Santos examined by the BO in the light of transfer policy so and so and its amendment dated so and so, and his representative considered sympathetically but rejected due to the above reason devoid of merit. And he had given 19 preferences for transfer in the previous paragraph written lordship, and this 116 battalion is also one of his choice posting. And the other 5 battalions which he have given lordship, that cannot be because it is in the home state, and also stated that one person cannot continuously place to his home place. This will hamper posting of other persons who are in other.
The present place of posting is in one of the preferences.
Yes, lordship. This paragraph 2 is there, lordship. Further, the individual has submitted his representation against his transfer through Santos, stating that he had obtained 19 preferences for transfer during SCT 2026, but he has been transferred to 116 battalion, that is out of 19 preferences, and also intimated that is so and so.
Well, these statements of this content of letter has to be substantiated by the records.
Lordship, it's
This just a column, my lord. There's nothing. It
No,
doesn't
but you
inspire
denied
the-
it.
My lord,
You deny.
what did, my lord?
Then the present place of posting is one of the choices you had given, preferences.
No, my lord. I mean, denying that, my lord, because my lord, in that particular software, it keeps track of every individual's posting. I am compelled to, my lord,
There
fill
is
up.
a-
Otherwise, it won't process, my lord.
You give us your choices of posting wherever you indicated.
My lord, at page 25.
Right. This is
78, my lord. 78 is in Kohima. 173 is in.
No, they say 19.
Yes, Lord.
19
Out of
options,
19.
19 preferences.
19, I don't think they'll allow
You
because,
submitted a representation through Santos.
my lord.
This is through Santos.
No, this
This
is
is not-
this is not so.
So where
This
is
is
that?
not-
So through Santos, what have you sent?
Santos before that order, Lord. This is after his
This is
transfer.
after rejection.
Yes,
Mhm.
not after rejection.
Not after.
After the
His
was
was issued, my
transferred
lord. Immediately it was issued, my lord.
on 22/12 it transferred. Then he
You
submitted.
show
it.
what options you had given through
My lord,
Santos.
in 20, the transfer order is issued at 20, in the month of December on 20/12, and on 23, my lord, I applied. I go and represent before the DIG, my lord.
We are asking you.
Santos, my lord.
Yes, because the instructions say there are 19 preferences given in Santos and you sent to one of them. So you
Then I have to take
eligible.
instruction, my lord. That
Get
can
your
be taken up
instructions.
tomorrow. Otherwise, my lord, it is Santos. My lord, if I don't fill up the preferences which are available to me, it won't process my application. If I'm compelled to fill up, my lord, because I don't have a choice. I have to fill up something. I have to fill up. Otherwise, it won't process my request,
Whatever it may be.
my lord. And my lord, these document, my lord, my
When can you
senior
get it?
president, my lord,
When can you get it?
tomorrow I can get it.
Monday.
Monday, my lord.
Released on Monday, enabling Mr. D. Gogoi, learned counsel for the petition, obtain instructions with regard to the 19 preferences that he claims to have submitted, that it is claimed by the respondent that he had submitted for the authorities through the SANTOS portal.
Well, can I play for status quo till Monday, man?
Till 19 he is protected. In that case, on
Till
March
19 expires.
Till 19.
19.
yes,
19
because order
19 is Friday, my lord.
so may not be necessary.
Status quo till 22nd.
20.
Status quo
Okay.
maintained till 22nd.
My lord, morning there was a prayer at the Landed Council of Finance. They are seeking adjournment, my lord. She wanted to dispose of the matter, my lord. I have the.
Released on Tuesday.
Tuesday. Okay.
On the request made on behalf of the respondent.
Reset home. Please complete.
What is the matter about?
Matter about the petitioner serving as assistant librarian in the Institute of Advanced Studies of Science and Technology, Assam. This institute was earlier granted under the government of Assam. On 9th March 2009, it was taken by the central government of India as a granted aid. When he was serving under the granted aid of the government of Assam, he was at the line of the UGC pay scale. He was granted the UGC pay scale in the year 2008, and that UGC pay scale has been withdrawn when it was taken under the granted aid of the government of India. Then, my lord, this pay was fixed in a lower pay grade. This is one of the aspects. Another aspect is that, my lord, earlier he had the promotional avenues for assistant librarian to deputy librarian, then librarian. These avenues also has been closed. That immediately after the refixation of pay, he is submitting returns in 2011. None of the representation is addressed. So I have approached the Honorable Court, they claiming that I am entitled to the pay scale because my grade pay, academic grade pay that time UGC granted as 8,000, and it was corresponding grade pay 6,600. That has been lowered to 5,400, taking me in the central CCS pay rules pattern. These are the basic. And another matter is because the UGC pay scale required to be given with the librarian in other institutes also. I have some examples. And law is well settled by the promotion, the promotion scope of promotion and consideration of promotion is a right, and that cannot be foreclosed. I am relying on some of the judgment. So, if your lordship permits the matter may be taken, my brother is ready. Otherwise, my lord, a date may be fixed.
Pleadings are completely listed for hearing.
Yes, my lord, date may be fixed.
No date, part 2.
My lord, sorry, please. My lord.
No, what
23,
please?
because man is going to retire.
Let him retire. You are
23,
concerned with the pay
23rd of July, otherwise I will make also.
Huh?
I can do it today on 23rd July maybe. He is going to retire.
Going to retire, what can be done?
23rd of July maybe can be.
Why? What are you claiming, essentially?
My lord.
What are you claiming?
My prayer. My lord, I am telling. 35.
35, yes.
A writ of Pendamas under any other appropriate date, directing the respondent to review the schedule 1 of the staff rules of the IASP Gauhati to please the.
To provide promotional avenue.
Yeah, that promotional avenues was earlier. Now it has been
Now it has been
withdrawn after taking the granting. Then, my lord, I am praying the directing the respondent to review the memorandum association rules and regulations to provide me promotional avenues.
So you have, your first prayer is for a direction for promotional avenues. Then you also have a prayer for refixation.
Refixation, because this will consequential. Because if I get this, then I will get. Then, my lord, I am coming to the bylaws.
If you get what?
I will get the pay also because my pay has been reduced. This is
what is the ground for claiming this pay ban?
Because I was drawing the UGC pay scale. I was drawing the UGC pay scale since, my lord, I have granted on the librarian pay scale in the March 2008, prior to taking over of this instituted by the central government of pay pattern. Then I made a bylaws at page 41, relevant as page 46. These are my service conditions when it was granted the institute of the government of Assam. 46, classification of staff.
Yes.
40. Then library staff, librarian, deputy librarian, assistant librarian. I am serving as assistant librarian. My promotional avenues was the deputy librarian, then librarian. I am a PhD holder doctorate in library science. Then, my lord, in page 49, earlier it was a bylaws of 2004 government service condition.
Scale of pay, the scale of pay, serial number 15, page 49. The scale of pay of the academic staff, registered FAO and librarian, deputy librarian, assistant librarian shall be the same line. Those are adopted by the UGC and accepted by the council IAST subject to fulfill their qualification as prescribed by the UGC. Page 49. Then this scale I was good. At page 61, on 28/8/2008.
61.
61. Office order. On approval of the Council of the IAST, the Director IAST is pleased to grant the UGC scale of 8,000 to 13,500 per month with other allowance admissible by the IAST to Sarindra Bustani Estel Levy with effect on 1/8/2008. The institute was taken up on page 62. Sorry, page 62 is a the human resources circular to grant of the pay scale. And here the scheme for revision of the pay of teachers, equivalent cadres in the university and college, and also post of registered deputy registrar. Page 63. I was drawing the pay scale, that is my the revised pay scale. I was on 8,000, 13,500 group A entry. Then it was revised to 15,600, 39,100 with academic grade pay of rupees 6,000. This was my scale when I was drawing prior to implementation of the central pattern payment. Government of Assam adopted the UGC pay scale, page 60. (11/5/2010).
Yes.
That was the UGC scale. That is the all the pay scale of the lecturer.
You are a librarian.
Librarian, page 69.
What is the pay scale you are getting?
I was getting the, my lord, I have shown the revised pay scale at a page, I have shown, my lord, the page 63.
63.
Assistant librarian. That was the P revise of 8,000, 13,500. That I have been granted on March 2008. That has been revised by on 4th June 2009. In the revised pay scale of 50,600 academic grade pay, AGP, 6,000.
What is academic grade pay?
Academic grade pay, that is, my lord, the assistant librarian. The academic institute, science academic institute, that is assistant librarian pay 63.
Is the librarian entitled to academic grade pay?
Yes, 63.
Yes.
Yes, serial number 2. Income back of assistant librarian college, scale 4.
Yes, UGC, anything to submit?
Lordship, UGC is actually not a party, it's not supposed to be a party in this petition.
Okay.
This is a technical institution and they have their own bylaws. The pay scale is also being determined by the government of India. UGC is per se not, UGC regulations are not applicable to this institution. For technical education, in fact, the AICT.
Why the UGC was added as a party?
My lord, that is the clarification, since he is saying, because that is applicable. I am showing at page 61. I have been given this pay scale of when I was in the government of 61.
This I have seen. This is prior to the bylaws coming into force. The bylaws have come.
Bylaws
into force
2004 was
from
holding the field.
Where are the bylaws?
Bylaws 2004 are holding the field.
Where are the bylaws?
Bylaws I am showing. Classification of the post.
Where itself it is written.
2004 bylaws. I am coming one by one. They are written. Page 46. Classification of staff. That bylaws governing my service conditions. Library staff. First of the serial number 10, classification of turn 1, academic staff, professor, associate professor, assistant professor, etc. Library staff, librarian, deputy librarian, assistant librarian, cataloger, etc. I am assistant librarian. I had the avenues of promotion to the deputy librarian, then librarian. Page 46.
You are now in which post?
I am not resting. I was stagnating since my inception 97. I am stagnating the same. Because
Which post?
assistant library.
Assistant librarian.
Because after that is my prayer.
Hmm.
When the
From assistant librarian, you should be promoted to deputy.
deputy, then
Then
librarian.
librarian.
That was the hierarchy. When it was a granted institute of the government of Assam, pilot 2004 governing my serving person. Then my lord, when it has been converted to grant of the institute of the central government, what they happened is my lord, I have then at the page 61, I got the UGC pay scale. 8,000, 13,000. This UGC pay scale has been revised. Page 60.
Revised.
Revised then correspondence 8,000, 13,500 granted the 15,600, 39,100 academic grade test 6,000. And page 60 the serial number is income tax assistant librarian. First of the associate assistant librarian all.
This was the discretionary of the institute concerned grant UGC scale of pay or not. Your lordship kindly peruses the further documents. All these documents have been signed by the Ministry of Human Resource Development, Department of Higher Education. So far as the revised pay scale is also concerned. The UGC is not governing it. It is the government of India that is governing. And if your lordship kindly sees page number 68, then this is a notification of the government of Assam Finance Department. Finance Department has not been added as a party in this particular case. And technical education falls within the realm of AICTE.
AICTE is not a party.
Not a party to the writ petition.
No. My claim is against in the institute. And I made the UGC party. If any clarification is required, then UGC will say.
is not in a position to give any clarification.
What is the stand of the institute?
Yes, my lord. Institute, my lord, at page 46, my lord, clarifies, my lord, classification of staff. Here, academic staff and library staff, it is completely different.
Page?
Page 46.
46.
Yes, ma'am.
Yes.
10 classification of staff. Here, academic staff. Academic staff means professor, assistant, associate professor, assistant professor.
He is asking for promotion.
Yes, right now he is asking for promotion. Where in the institute there is no post of deputy librarian or librarian, because it was earlier it was under state government granted in institute. After that it was converted into central government institute, and everything is your lordship governed by the central government rules, my lord.
Where
That
are
is,
the rules? What rules?
that is, my lord. After conversion, my lord, the pay scale has been fixed as per the Central Civil Services revised payroll 2008. Earlier, it was the government of Assam granted in the institute. Since it has been converted, and the entire all the scales of the employees have been converted into the revised pay scale of 2008 minus CCS rules. And in that case, my lord, there is no post of assistant librarian, deputy librarian, and like librarian. So since he was earlier, it was he was a library staff, and later on when it was converted as per the rules, my lord, CCS rules, there is no assistant librarian and deputy librarian. So there is no scope for promotion, my lord, in that case.
Which rules govern the services now?
Services, CCS rules, my lord.
No. My lord, I am appreciating. Not service condition governed by the bylaw 74 page 2009. That is my case. That is what I have submitted in my prayer. These bylaws, after the from 9th March 2009, that is from the date of taken over by the central government as a granted it. Here, my lord, bylaws comes, and bylaws is page 79. Category of staff, classification of employees of IAS, academic staff, director, professor, associate professor, assistant professor, technical staff, technical officers in the grades of so technician in the grades of certificate, administration. There is no whisper of the library staff. Earlier it was in the 2004 bylaws. That is why my prayer before your lordship is there, create an avenue for promotion.
So it is governed, there is a governing council.
Yes, my lord. There is a governing council, my lord.
So is there any order passed by the governing council regarding inclusion or exclusion of posts
Post, my
from a
lord,
particular grade or category?
because my lord, this memorandum of association, which was been, my lord, the 2020, 2004, my lord, that is page
This,
number 41.
what we want
Yes.
to know is page 79, clause 14.13
Yes,
talks about administrative staff.
yes.
So
Administrative.
it refers to Hindi translator and such other posts. What does this post include?
My lord, the librarian has been excluded as it was in the earlier bylaw.
If you are excluded, then how are you working? In what capacity?
That is they are taking classified
As
the
a technical
librarian
staff,
as a
my lord.
technical staff.
All the other
And
staffs are,
avenues of promotion has been
Where are these grades reflected? 14.1 Roman 2. Technical officers
Technical
in grade
staff.
number so and so. Where are
Yes.
the grades reflected?
here, my lord, technical staff, since in the rules, my lord, there is no library staff and other stuff which was in the state government institute, my lord, earlier, my lord. So all are grouped into technical staff, my lord.
But there has to be some decision of the governing council or some authority to say that how these posts are now taken under.
Yes, my lord.
Classified or nomenclature.
Yes, my lord. In the year 2009, my lord, since it was converted, my lord. After that, my lord, this bylaws has been enacted, my lord.
But whatever
So according
posts
to
were
this,
there earlier,
yes, my lord.
after conversion, what has happened to these posts? How are they classified?
Because in earlier, my lord, 2009,
Like if you are putting librarian in a technical staff,
yes, my lord.
then you must define what is technical staff
Yes,
besides
my lord.
librarian.
Yes, my lord.
Is it reflected somewhere?
Because technical officer in grade is C, D, and A. In bracket, minor. Technical assistant in the grade 2 and 1, minor.
Page number 102
Yes, minor.
gives the various posts.
Yes. Yes, minor.
The serial number 29 is library assistant.
Yes, minor.
There is no librarian.
No librarian.
Or assistant librarian.
assistant librarian is there.
Where?
My lord, page 102.
24.
Scale of pay. Page 102 scale of pay, they have given the assistant librarian. Here is my grievance. They have categorized me as an assistant librarian and my grade pay has been given as 540. I was earlier drawing the scale of academic grade pay of 6,000. Now they have been reduced my grade pay as 540.
My lord, the institute was converted in 2009, my lord. And the UGC pay scale has been revised in 2009, my lord, June, my lord. That is, conversion has been made in the year 2009, March 2009, my lord. Since all the posts have been already, the salaries and the basic pay has been already fixed as per the central government, my lord, rules, my lord. That is why the UGC has, the pay scale has been revised on, my lord, June 2009, my lord. Already, my lord, all the employees and the salaries has been already been fixed in under CCS rule, man. That is why, man. Because his earlier, as per his earlier pay scale, my lord, his pay has been fixed, my lord, under the CCS rule, my lord. And after fixation, the UGC has revised the pay scale, my lord. And right now, he is claiming, my lord, the petitioner is.
UGC says they have no rule.
My lord, as per his claim, my lord, the petitioner's claim, my lord, he was serving as a assistant librarian under the pay scale of, yes, my lord, that 8,000 to 13,500. That was his earlier pay scale when he was serving in the my lord, as an assistant librarian in the ISTC under the state government, my lord. That is the UGC scale. What he was drawing at the time of, my lord, before conversion, my lord. After conversion had been made in the March 2009, my lord. And the UGC has pay scale has been revised in June 2009, after fixation, my lord. Now he is claiming, my lord,
that as per this, my lord, the fixation, my lord, that means the revised, my lord. Since he was drawing the pre-revised, so his pay was fixed as per the pre-revised scale, my lord, in the CCS rule.
Now, under the CCS rule, what is the scale of pay? What is the grade pay that he's entitled?
He's entitled, my lord. Now, which has now he is drawing, my lord. That means
I have my HTTP in reply page 24 and 25 may be considered. 244. 244, 245 may be. 244, that was given after revised of the pay scale, pay rules, introduction. They have given me. My name is
There
yeah.
in the petition only. This document is available in the writ petition only.
Yes, yes. No, not in writ petition, but in my affidavit in reply. And then my lord, a grade pay applied 6,000. Here, my lord, lordship may kindly consider. I was in the pre-revised pay scale of 8,200, 13,500. Similarly, my lord, at page 245, one Debasis Choudhury serving as assistant professor, 245. He was also in the same pay scale, 8,000 to 13,500. He has been given the revised pay rule 6,600. Page 245.
245 is
Debasis Choudhury.
your service book.
Debasis Choudhury. Page 245. 244 is mine.
The assistant professor.
yes, only he is academic, my lord.
Assistant librarian, I'm my pay scale, they revised.
That is a
There
difference,
is-
my lord.
I was just doing the same
reference which you are giving is of a person who is assistant professor.
same pay scale. We are doing because earlier I was. That has been withdrawn. That is my grievance.
Because earlier
Because
the technical
I have been lowered, whereas the assistant professors, assistant professor has been same. We are doing the same pay scale. He is
No,
also
you are doing the same pay scale. Is the nature of your work one and the same?
no. One the submission is there. My lord, he was serving as a. I had also the avenues like that. The librarian, assistant librarian, and he is also same. That is then his pay scale has been given 6600 revised. Mine have been lowered to.
You are not an academic staff.
Maybe I am not academic, but my grade pay has been lowered. He has been given the higher grade
He has
pay.
been given
All we are getting the UGP. All we are drawing the UGC pay scale. They are also doing the. I was also doing.
No, today you are not drawing UGC pay scale.
That time I was doing. That is before the lawsuit. Because this is one of the aspects.
Subsequently, the institute been taken over by the central government.
Yes. Yes.
The,
That's my pay scale cannot be lowered.
there is that order of taking over, handing over, taking over. Reflection. Where is that?
Another pair is my promotional avenue has been foreclosed. I realize some judgment of this like. The Supreme Court is you cannot foreclose the promotion channel forever.
That is for for you to agitate at the time when the institute was taken over.
Yes, in 2011 I have submitted it.
Huh?
Since 2011 I am submitting.
You are making this claim in 23.
No, I am 2011 I am submitting. They have not given reply 2011 since 2011.
My lord, page number 103, my lord.
Page 121 I submitted my first representative. It was on 15 November 2011. Then my lord, one governing body, my lord, they considered here. I have enclosed my affidavit. Then I submitted it 2021 also. In between something, some representation not provided. I have page 121. I have come to know there is no provision for higher post next assistant librarian caretaker which is available for other staff in our institute. But due to the importance of the increase of workload deputy by friendship, also for a provision of the future prospect of the service employee caretaker, it is important to make scope provision for some higher post.
Where is that order? of
Yes,
taking
madam,
over?
105, page number 105, madam, annex 10.
This is only the order. There will be a proposal. What is the proposal?
My lord, in 103, my lord, that is office order, my lord.
You come to 105.
Yes, ma'am.
You see there is a proposal for conversion. Where is that proposal? It is the proposal which will reflect how the staff. What will
Here,
be
my
the
lord,
what will be the position of the staff? It will know. Produce the proposal.
Yes, my lord.
Formally. And claim of the petitioner that the great way which the petitioner was drawing as per the UBC scale when the institute was under the state has not been granted to him after the institute has been taken over by the central government. So the further claim of the petitioner that earlier there were avenues for promotion. The petitioner from stock assistant librarian to that of what
Librarian, deputy librarian, then
deputy librarian and librarian. So, however, these avenues are not available after the state was taken over by the central government. So, the other limbo of argument of the petitioner is that his great pay earlier was considered he was entitled to the great pay as he was considered to be a part of treated to be the post of assistant librarian was considered to be an academic part of the academic staff. So, post taking over by the central government, the post of librarian has been shown part of the technical staff, and therefore his great pay, getting a lesser great pay than he was prior to taking over. So, having examined the reading before the seen that by order dated 27th of May 2009, the Ministry of Science and Technology, Government of India had informed the state regarding the approval by the cabinet, central cabinet, regarding taking over of the institute by the central government. So, however, from the pleadings, the proposal for conversion of the institute to an autonomous grants in aid institution of the Government of India under the Department of Science and Technology is not available. The PD stop. Whether the council appearing for the institute, Mr. Goy, submits that he would furnish a copy of the same the next day. So, Para MSP Agarwal, the council appearing with UGC, submits that UGC is no longer not a necessary party. Read it as in May. This submission will be taken into account the next returnable date. When the matter will be taken up upon production of the proposal for conversion as directed by the court. Thirty July.
Partner also.
Whatever, if it comes as partner, it will come.
Substantial part of the argument about it.
All right, partner. Yes.
Not his petitioner. They're all. Not may kindly have item number 10.
Then WPC 925.
Yes. Not petitioners, they are all general pool Central Armed Police Force officers. They are group A officers of the Government of India. But there is a policy of the central government. Whenever these officers are transferred to Northeast India and some other location, then as per that, in fact, there is a rule, they can retain their family accommodation in the earlier place of posting for a period of 3 years. And in the northeastern region, they will not get family accommodation. They will either they live in officer mess or something like that. Now, this provision has been made by virtue of a 309. Now, my lord, that rule has been now tinkered with by an executive instruction. That is the challenge before your lordships. Now, some of the officers who have completed, my lord, 3 years, many have left, or many are there. But if they are staying beyond 3 years, in this case, they will have to pay a particular rent, my lord, penal rent, that they will pay for retaining the quarter in the earlier place of posting. This is the subject matter of this.
So what you are essentially agreed by what?
We are agreed by this order, my lord. The lordship would kindly come to page 104.
10.
This is the impugned order. The subject itself suggests a review of incentive special allowances. Page 104. 6th of October 2022. A review of incentive special allowance granted to All India Service
and central government group A officers working in Northeast region. A reference is invited to this directorate's OM number dated so and so, granting benefit of retention of GPRA, that is General Pool Residential Accommodation, on posting to Northeastern region, treating the region as a non-family station. Benefit was subsequently extended from time to time by OMs dated so and so, so and so, so and so. That is up to 3624 million. Now the government of India has refused the incentive special allowance granted to all India service officers and central government UK service officers working in Northeastern region. And accordingly, it has been decided to withdraw the benefit of retention of government accommodation at the last station of posting insofar as it relates to Group A officers, including all India service officers, as was granted by above quoted OMs. But interestingly, this benefit was being given to the Group A officers as well as to Group A and Group C officers. But as far as Group B and C is concerned, well, those have been retained. As per the above, no fresh retention at the last place of posting shall be granted to Group A officers, including all India service officers with immediate effect, in case of their posting to Northeastern region, including Sikkim. However, provision of such retention to officers posted in remaining non-family station, Jammu and Kashmir, Ladakh, Andaman and Nicobar, Lakshadweep, so and so areas as declared by Ministry of Home Affairs from time to time shall remain in force. So only in case of Northeast, it has been withdrawn. Moreover, the retention already granted to such officers who have earlier been posted to Northeastern region will also be withdrawn, subject to stay already granted by court of law against any vacation order giving opportunity to the LOT officers to vacate the accommodation, that is by 31/3/23. In all the above cases, as mentioned in para 3 and 4, the normal retention period allowed on transfer under Rule 40 of CGPA, Rule 2017 shall remain applicable from the date of transfer. Now here, Lordships will kindly notice two aspects, my lord. In para 4, they say they after 31/3/23, they will have to vacate. That means, my lord, penal rent will start counting from 1/4/23. And the other aspect is, my lord, 5. In all above cases as mentioned in para 3 and 4, the normal retention period allowed on transfer under Rule 40 shall remain applicable. Now, as far as this Rule 40 is concerned, your Lordship would kindly come to page 115. Sorry, page 113. Rule 40. LOT may, subject to the conditions laid down in these rules, be permitted to retain the accommodation on the happening of any of the events specified in column 2 of the table below for the period specified in corresponding entry in column 3 thereof, provided that accommodation is required for bona fide use of the LOT or members of the family. Resignation, dismissal, removal of service, only 1 month. Then, my lord, similarly, in case of other contingencies, different period has been prescribed.
For transfer?
Transfer, it is not there. Transfer, Roman 7. Transfer on deputation to public sector undertaking 6 months.
No, number 3 is also there.
My lord.
Serial number 3?
Transfer to places outside the existing 2 months. Yes. Now, this is not the position. Position is, please come to page 115. Retention granted on posting to non-family station. So, yes. My lord, this is a field covered by statutory rules. The, my lord, OM which I read just now,
That is an executive instruction. How it can override this? Now please come to rule 43. The detention granted to allottees including Agmut cadre officers of GPRA at their last post of posting in case of their posting to different non-family station for bona fide use of their family members under different guidelines of Government of India issued from time to time will be restricted to maximum 3 years. So, my lord, if an officer is transferred to a non-family station, then for the bona fide use of the family, it is already provided in Rule 43 that it will be permitted for 3 years. So, how you could have truncated this by the impugned order, which is at, my lord, page number 1044. That is our basic case. And in fact, this Honorable Court has passed a stay order, Miller, after this 6th of October OM. Now, this is, kindly see, this is a executive instruction.
Where is the one?
104. Now, my lord, there is a reference to OMs in paragraph 1. By virtue of these OMs, my lord.
So earlier, prior to the OM, what was the period?
3 years. It's covered by rules.
3 years.
Yes. Now, what they have done, because in this impugned OM, they have mentioned the date of 31/3/23. Now, they have imposed Miller penal rent. And Lordship has protected us.
So your 3 years will expire when?
The question is, whenever my 3-year period expires, thereafter, if I don't leave, then I am entitled to pay penal rent. For that period of 3 years, different officers are there.
In terms of the OM, what is the period?
31/3/23, para 5(4).
So from 1/4/23.
Yes, 1/4/23.
But there is no particular period mentioned under the OM.
No, my lord. The OM says, in the first paragraph, it says, my lord, by this OM, different dates were fixed. Am I clear, my lord? Now, I'll have to place another OM, my lord, page 102, then position will be clear. 102, my lord.
102.
Subject retention of general pool residential accommodation by central government. White OM dated 10/4/18, retention of central pool residential accommodation at the last place of posting by central government civilian employee, including CAPF employees, officers of all India service posted in non-family station, was extended up to 30/6/2021. It has now been decided to further extend the concessional retention of general pool residential accommodation at the last place of posting by central government civilian employees, officer service on their posting to non-family station for a further period of 3 years, that is up to 30/6/2024. So this was the last period. Now, because in the impugned order, my lord, they mention a date of 31/3/23. Therefore, they are construing that whosoever is retaining family accommodation in the last place of posting beyond 1/4/23, they have started imposing penal rent. Our case is, my lord, the dates will vary. It's not that all the officers were transferred on a particular date. So, from date of transfer, for a period of 3 years, they are entitled to retain their earlier accommodation at the last place of posting. So thereafter, if somebody is retaining, then may not you impose penal rent, but not otherwise.
So the effect of the OM at 102.
Yes.
Is that this 3-year period?
Yes, will come to an end on 36/24.
24.
But nevertheless, my lord, by the impugned order at 6/10/22, they say
it will be end
It
for
will
one
be
four,
end on 31/3/23.
23. You are not agreed by this 102.
Certainly not. Just for recital of facts, we have given that. And that was actually not required, my lord, because the rule is already there. Rule 43.
So what is the purport of 102?
Purport of 102 is, my lord, the period which was earlier up to 30. 1 second.
Under the rules, there is no period fixed as such.
No fixed. Not fixed.
Then what is the purport of 102?
My lord, that is our whole case. When a subject matter is covered by a statutory rule, can you issue an executive instruction to tinker with the, my lord, scope of the rules? That is our basic challenge. Right from Nagaras to all these cases, Supreme Court has said, my lord, yes, supposing there is a gray area in a statutory rule, then there is certainly an executive on a subject on which the appropriate government can make a law. On that subject, appropriate government can, in case of central government under 73 article and the state government under article 162, can, my lord, since they
Now, by virtue of the
order, yes,
what essentially they are doing is giving a retrospective effect.
Yes.
Over and above.
Yes.
102 has been superseded.
Yes. Not only that, my lord, they have also slapped the, my lord,
Penal.
My lord, we have filed an additional affidavit where we have annexed that, my lord, page 336. Now, this is the effect of this. Page 336, it's part of the additional affidavit. Calculation sheet detailing the telescopic damage. Lord, otherwise in Norman official terminology, we say penal rent. They call it telescopic damages. For example, in WPC 925, these are the people involved, my lord. And these are the amount which has been now sought to be recovered. 14 lakhs, 61,000, 65 lakhs, 4 lakhs, etc. 43 lakhs. Then WPC 1960, from somebody 78 lakhs, 44 lakhs, 1 crore 70 lakhs. Samir Kumar Srivastav, he did not have to sell his property. This is the effect. Lord, to put it in nutshell, we have under Rule 43, we can retain up to 3 years. The moment I am transferred to a non-family station, then they will count the period. Supposing on, say, 2021, Lord, I am transferred to Northeast India, January 2020. So from February 2024, if I retain, you charge penal rent. If I have handed over the accommodation, end of the matter. So our humble submission is, my lord, this order at page 104 is without jurisdiction. It is contrary to the rules, and therefore, my lord, it cannot withstand. And in fact, in Delhi High Court also, my lord, similar litigation was there, where relief has been given to the similarly placed persons. Kindly have a copy of this. This come to para 64, my lord. My lord, what had happened, my lord? the challenge in before the Delhi High Court was slightly different, where they said, my lord, that this fixation of 3 years in Rule 43 is arbitrary. So, my lord, it is in that perspective it is said, para 64 at page number 32, in conspectus of the facts and circumstances whereof the considered view, that Rule 43 of the so-and-so rule cannot be held to be arbitrary or violative of Article 15, inasmuch as the same has been framed upon due consideration of all factors. Imposition of 3-year cap on retention of accommodation does not appear to be either whimsical or fanciful, so as to invite the vice of arbitrariness, thereby warranting imposition. It is a settled position in constitutional jurisprudence that court must exercise a restraint and refrain from interfering with the policy decisions or statutory rules by the state, so long as they are not unconstitutional, irrational, and manifestly arbitrary. In any case, my lord, here the challenge before the Delhi High Court was that 3 years is less.
Challenge has been rejected.
It's slightly different. So here, my lord, our case is very simple. When the issue is covered by a rule, my lord, you perhaps cannot come up with, executive instructions.
Yes.
So therefore, our submissions are, my lord, first, executive instructions cannot override statutory rule framed under Article 309. Now, we also say, my lord, that the impugned OM is violative of Article 14 because only Group A officers have been, the incentive only in case of Group A officers has been withdrawn while retaining the incentive for others. And, my lord, most importantly, in the affidavit filed by the Government of India, they have also taken a stand that the situation in Northeast India is conducive. Therefore, there is no longer requirement of incentivizing the officers to come to Northeast. But fact of the matter is, my lord, 31 districts of Northeastern region were still Armed Forces Special Powers Act are in force. Everywhere, my lord. Even in Assam also 2-3 districts are there. And, my lord, there's very interesting part. Lord, BSF, they guard the border, my lord. Now, my lord, CPWD officers who are entrusted with the work of, say, border fencing, whom the BSF guard, they will not get the benefit, but CPWD officers will get. These BSF officers are who is providing protection to these CPWD engineers, my lord.
Same set of rules apply.
Same. If your lordship would kindly come to page 319 of the additional affidavit, my lord. Look at the irrationality, my lord. This is another office memorandum of 7th of May 25. Extension of retention of general pool residential accommodation to officers and staff of CPWB on posting to border fencing, road and flood lighting project, etc. along Indo-Pakistan, Indo-China and Indo-Bangla border for a period from so up to 2030. In continuation of this Directorate's office memorandum even number dated, undersigned is directed to state that it has been decided to extend the concession of retention of GPRA at the last place of posting to officers and staff of CWD on the posting to border fencing, road, etc. etc. Fairly similar. How irrational the decision is. Either you give it to or don't give it to anybody. How can you identify who is, my lord, discharging a better role, who is discharging a less important role? I'll just place 2-3 documents, my lord. Page 272 of the additional affidavit, my lord.
Now, in case of Milord Sikkim, Andaman Nicobar Island, Lakshadweep, State of Jammu and Kashmir, this is continuing. Page 272. Then, Milord, if your Lordship should kindly come to 274. This is of 30th of March 2026, same Ministry of Home Affairs. Regularization of retention period of general pool residential accommodation beyond 3 years by Central Armed Police Force personnel posted at non-family station, allowing them to retain till 31/5/26 as one-time measure. Then Lord will kindly come to then Milord page 3 and 19 regarding CPW I have already placed. So these are the Milord So, Milord, therefore, Milord, on the whole, Milord, our submission is very simple. Your action of calculating panel rent from 1/4/23 is absolutely without any authority of law. A direction should be issued to the central government, Milord. They should result from that. And Milord, whosoever has completed 3 years, thereafter, if somebody has stayed, that's a different aspect. And many of the officers, my lord, they have already handed over their accommodation in the last place of posting on completion of 3 years. Because we are conscious of the fact that on completion of 3 years, we can't retain. And if we retain that at our peril, we'll retain. So, my lord, on a legal perspective, it's a pure and simple case where Government of India in the relevant department has exercised jurisdiction which is not vested in. Because the field is covered by a statutory rule. You cannot tinker that with any executive instructions. And my lord, this calculation should be, my lord, interfered. And my submission. Subject to what my learned friend says, my lord, I reserve my right of reply. I'm placing the notifications in the chat. I'll also be referring. If I may take your lordship to the bunch of papers, more particularly to the rules that your lordship will find from page 1 to 25. I'll take your lordship to rule 40. Rule 40, my senior has referred to it.
Rule 40.
Yes.
That would mean
That would be in page 12. I have given the page numbers
in
the
this
right-hand
bunch
side. Yes.
compilation.
Yes, yes.
Page number?
Page 12 of that compilation. Top right-hand side. Page number is given.
Yes.
Yes. This is lordship concessional period of retention. What happens is, lordship, when they retain, they are not paying the full license fee.
They are not.
They are not paying the full license fee. They are paying at a concession. Even the petitioners out here. The LRT may, subject to the conditions laid down in the rules, be permitted to retain the accommodation on happening of any of the events specified in column 2 of table below for the period specified in the corresponding entry. So, my senior was referring to 7. 7 is of course not attracted if you are not able to see. The next page. 7 is on transfer or deputation to public sector undertakings. This is not that condition. So your lordship will see. Next is Rule 43. Lordship will find at page. Retention granted on posting to non-family stations. This is what my learned friend is on. Retention granted to LOTs including advocate officers of GPRA at their last place of posting in retention in case of their posting to different non-family stations for bona fide use of their family members under different guidelines of the Government of India issued from time to time will be restricted to a maximum of 3 years. As you can see, will be restricted to a maximum of 3 years. Now, the petitioners for your lordship are all members of the CAPF. Well, that is the Central Armed Police Force. And lordship will just bear in mind the quarters, the residential accommodation, because these accommodations were previously the Delhi estate accommodation rules. These accommodations are in Delhi. Once the officer is posted from Delhi to a northeastern state or any other non-family station, they are entitled to retain a quarter there up to a maximum period of 3 years. Now, what happens if the period extends? My friend was on that.
Period extend
Means if the period of posting in this
beyond 3 years.
if it is beyond 3 years, in that case, they get an extra special HRA. They have to vacate the quarters, but they get a special HRA, which your lordship will find mentioned in the judgment referred to by my friend. So, after 3 years, they have to vacate it because they will be entitled to a special HRA for that period. Now, damages. If damages is the penalty that has been levied on the petitions. Rule 76, lordship may see, page 24. Page 24. The rates of damages for unauthorized occupation or subletting or misuse of accommodation, servant quarters or garage shall be specified by the Directorate of Estates from time to time. And it has been specified, and as per the specification, some penalty has been levied on the petitions. Now, it is not a case of the petitioner that they have or they are required to move out of that accommodation beyond the period of 3 years. I mean, within the period of 3 years. Your lordship will find the prayer made in the writ petition is that they should be allowed to remain till 36-24. Now, after 36-24, as my learned friend vacated the quarters. He has not. Therefore, the question of levying penalty will definitely come in. If at all, lordship.
Those will later work. First explain to us the concept of the rules. The rules say it will be restricted for a period
Of 3 years. So in any case, if I may concede to a fact that yes, I have made a mistake in issuing some OM, but the OM will definitely not override the rules. So it will be restricted to 3 years in any case. It will be restricted to 3 years in any case, and that is my case. And if that 3 years has elapsed in the meantime, they are not entitled to retain their quarters. Now, so far as retention of quarters, I've given the copies of the relevant OMs also. If your lordship will come to page 26, this is the OM dated 10th April 2018. I'll take your lordship to point number 2. And 3. Only those CAPF personnel who are working and posted in headquarters are eligible for such concessional retention. It is clarified that the facility of concessional retention of GPRA at the last place of posting for central government civilian employees, including CAPF employees and officers of All India service, is permitted only when the LOT of GPRA is transferred to non-family stations from other places and is not permitted to the central government employees who are repatriated back to his her parent office in non-family stations on completion of their deputation from other places. In the present batch of cases, there are officers who have been posted to the northeast and they have again been reposted back to Delhi. So only CAPF personnel who are working and posted in headquarters are eligible for such concessional retention. And now, what is a non-family station? Lordship will see the next OM, page 28. That is 1st August 2018. It has been defined and northeast does fall within a non-family station. Now, what I was on, I had made a submission, Lordship, that they would be entitled to a special extra HRA. Lordship will come to page 29. Page 29. The undersigned is directed to say that a proposal for grant of HRA of old station selected place of residence in addition to the HRA admissible at the new place of posting to CAPF personnel on their transfer to non-family locations is northeastern region, Sikkim, Andaman and Nicobar Islands, Lakshadweep, so and so areas in the event of their vacation of government accommodation retained by them after 3 years. After 3 years, as per Ministry of Housing and Urban so and so, dated 14/11/2017 and 1/8/2018, till they remain posted in such non-family stations was examined in this ministry in consultation with the Ministry of Finance, Department of Expenditure, and it was agreed to allow HRA on vacation of the government accommodation by families of CAPF.
Under the rules, what is the provision for special HRA? Nothing.
It is not there.
Not there.
It is not there.
Silent.
It is silent, Lordship.
So you are bringing this special HRA by way of OMs.
This is by words, Lordship. Now, I was on point number 1. Allow HRA on vacation of the government accommodation by families of CAPF personnel after 3 years retention period who are posted in non-family stations locations as defined by Ministry of Housing and Urban Affairs in their OM dated 1/8/18, in addition to the HRA admissible at the new place of posting. So they get it in addition. Relax the mandatory provision of keeping families of CAPF personnel at last place of posting for allowing HRA at the rate of the selected place of residence. Now, once this further makes it clear that once the period of 3 years expire, you are no longer entitled because you are entitled to a special HR. This does not tinker with any rule notion.
So what was the need to issue the Indian web? If 3 year is there, the different dates from their dates of transfer, 3 years, you had 3 years. Why these OMs were issued?
Yes, Lordship. Now, here is a case, Lordship, where they are continuously occupying.
So the rules are there, you can take action. If they're continuously occupying,
yes,
from the dates of their transfer, you had 3 years thereafter.
Yes.
Where was the need to issue?
No, if I may just for a moment, Lordship.
Rules are very clear.
If I may take your Lordship to page 30A.
Page?
Page 30A.
30.
30A. Now, page 31 was issued in pursuance of this. The undersigned is directed to inform that the government has reviewed the incentive special allowance granted to the All India Service and Central Government Group A service officers, and accordingly it has been decided with the approval of the competent authority to withdraw the benefit of retention of government accommodation in last station of posting available to the central government employees insofar as it relates to Group A officers, including All India Service officers, as was granted by Ministry of Housing so and so, dated so and so. Pursuant to this, now that benefit which was being given, that has been withdrawn. Now, if that benefit has been withdrawn, the claim to the quarters will no longer be there. And that is why the second OM has come, that is on 6th October 22. From paragraph 2 onwards, if your Lordship will read. Now the government has reviewed the incentives, special allowance granted to All India Service officers and Central Government Group A service officers working in Northeastern region, and accordingly it has been decided to withdraw the benefit of retention of government accommodation at the last station of posting insofar as it relates to Group A officers, including All India Service officers, as was granted by so and so. Now, Lordship will just bear in mind, this is only in connection with the accommodation which is provided by the Ministry of Housing, Directorate of Estates, which follows the rules of 2017. This does not preclude the petitioners from availing the quarters which are available in their own force. I will just take your Lordship to the judgment referred to by my senior. I will take your Lordship there, where the Honorable Delhi High Court has taken note of that. If I may take your Lordship to page 28 of that judgment of Delhi High Court. I'll read from paragraph 51 onwards. The respondents, while defending the rule, submitted that the same were duly notified on 16/6/2017 in exercise of powers conferred under provision of Article 309 of the Constitution of India and has been laid before both houses of the Parliament. Further, the cap of 3 years for retention of government accommodation is necessitated by the limited availability of residential quarters and the demand for the same. The continued retention by outgoing employees hampers allotment to those who are subsequently also posted to non-family stations in comparison to those who are posted to non-family stations from time to time. The respondents also submitted that in cases where CAPF personnel are posted to non-family stations for a duration exceeding 3 years, they are entitled to additional HRA, which I have already submitted, which is over and above the HRA given at a new place of posting. Furthermore, CAPF personnel are afforded the flexibility to keep their families either at the last place of posting or at any other location of their choosing across the country and may accordingly claim additional HRA. The respondents brought to the notice of this court a demand and availability status. This is the demand and availability status. So the demand is more than the availability. Now, paragraph 55, it is evident from the above that there is a significant shortage of GPRA quarters and an additional HRA is being paid to the CAPF personnel in case this posting continues to non-family stations. And next paragraph, paragraph 57. Although the aforementioned observations were made in the context of reservations, this is with regard to the observations made in Indra Sawhney's case, the foundational principle laid down remains equally applicable to the present case. That is, of maintaining a delicate balance between the competing rights and rival contentions of the parties. In the light of the aforementioned principle of law, it is to be noted that freshly posted employees are equally entitled to accommodation under the provisions of the GPRA rules, and such entitlement is not confined to the members of the CAPF, but also extends to other central government employees. This court cannot thus lose sight of the fact that a large number of employees of the central government and CAPF are awaiting their allotment and are being deprived of the benefit of allotment of the government accommodation for long periods. So now, BSF, CRPF, or any other CAPF lordship, they do have quarters. They can very well avail those quarters. They are not precluded from doing that. This is only with reference to the quarters under the Directorate of Estates. And it is brought out in this judgment that the quarters in the forces, they are vacant. It is there.
They are perhaps not well maintained.
That is, lordship, they are the boss of the forces, lordship. The officers before your lordship are the persons who are going to maintain it.
Then?
Therefore, lordship, it is not a case where they would be only retaining their quarters.
No, there is only one clarification that is necessary.
Yes.
That rules have not been altered.
Rules have not been altered, lordship.
So the rules are clear that it is
I would very well say, lordship,
day
it would be the period of 3 years. And if your lordship makes an observation that from the date of their posting to this present place, if it has exceeded 3 years, they do not have
they do not have a.
They do not have any right of retention.
They are not concerned with the right of retention. They are concerned with the penalty that you have imposed.
That is a part of the prayer. Now, it has fallen from my learned friend that they are very aware that they would not retain. Now, if they are aware and they have retained penalty as per the rules.
But that still doesn't explain why these two office memorandums were required to be issued. What is the effect of that?
Effect, lordship, would be that, to my understanding, I would just submit, lordship, is so far as the quarters accommodation under the Directorate of Estates is concerned, that has been done away with. That has been done away with. Because this will not override the rules relating to the quarters which are available to the forces. It is only with regard to the accommodation which is maintained by the Directorate of Estates.
that these are available in Delhi,
Yes,
only in Delhi.
all the petitioners are from them. I cannot argue much on Rule 43 since it has been upheld by a division bench of Delhi High Court. But that also confines the retention up to a period of 2 years. I'll just pass on a copy of the OM by which the penal charges were fixed. That is 2016. So
Yes.
in the meantime, Lordship, during the pendency of these matters, Lordship, the license fee
No,
has
that's
also.
what we asked you.
Yes.
You said it is in Delhi. It doesn't appear to be in Delhi alone.
No, the petitioners.
Ah.
Petitioners are from Delhi.
No, not but these rules, these accommodations are across the
They
country.
are across. They are across. They are across.
Last place of posting, maybe there will be many eminent.
Where are the rates specified under the rule?
Uh,
Under the rules, is there anything?
no, Lordship, that has been done by way of OMs. The latest one I have got.
We have annexed that, page 329.
No, under the rules, there is no mention about the fee.
No.
The
That is being revised from time to time.
no revised is okay, but
that has been
essentially was it mentioned in the schedule to the rules or something like that? Nothing.
Lord, just to reply to my learned friend's contention here. Now, my Lord, on principle, my learned friend also does not dispute the position that up to 3 years we can retain. Now, my Lord, I am just trying to visualize a situation. Normally, my Lord, whoever comes to any hard area, as per the transfer policy of government of India,
on completion of the period, Miller, normally the employees are given a choice posting. So, Miller, on completion of 3 years, you should have taken us back. In which case, this problem would not have arisen. Maybe there are other officers are not willing to come to Northeast because it is a non-family station. Miller, therefore, these arguments should be never ending. That is not the issue. Issue is, my lord, this field is covered by a statute framed under Article Proviso to Article 309. It says, whenever you are posted to a non-family station, you are entitled to retain your family accommodation in the last place of posting for a period of 3 years. Now, my lord, if the government of India, in its wisdom as a welfare state, wants to incentivize the people by giving special HRA, etc., etc., that is in a different realm altogether. That cannot offset Rule 43, my lord. That is in your wisdom, in your good gesture, you have done it, we accept it. But
the learned CSGI agrees to your submission
yes,
that it's for 3 years.
Yes. The moment it is 3 years, beyond 3 years, my lord, if we have not vacated, then my lord, consequences will follow. That we cannot, that is not my case. But I was just only trying to understand the problem. On completion of 3 years, why have you not posted me back to any other place? In which case, this problem would not have arisen. Because in exigencies of public service, I am still serving in Northeast, which is considered to be a difficult, hard area. And kindly similar, same homogeneous group who is serving in Ladakh, who is serving in Jammu and Kashmir, is getting the benefit. So what is that intelligible difference here based on which, my lord, this distinction has been carved out? And my lord, lordship, no, there are, I'll just pass on 3 judgments, my lord. Yes. My lord, the first is Santram Sharma, AR 1967 SC 1910, para 78. Then, my lord,
What is the status of the Delhi High Court judgment?
Delhi High Court said this upheld. Upheld the rule.
Supreme Court.
Yes. No, Supreme Court has not interfered.
Supreme Court has sent the matter.
Same Miller. Supreme Court has upheld, no?
No. Supreme Court has sent the matters to Gauhati. All matters. Now the cases before the Delhi High Court are cases where the petitioner's counsel submitted before the court that will not be peaceful.
Anyway, Miller, eventually this honorable.
You are saying that these are a part of the series.
Yes.
It is mentioned there in paragraph, lordship. I will just write out.
Now, Miller, against the Delhi High Court's order, which I have also placed, to which my learned friend is also referred, Supreme Court has upheld it. And Miller, that is regarding validity of Rule 43 and the specification of 3 years. Now, Miller, I am on the other point, Miller, that executive instructions cannot override statutory rule. I am relying on 3 authorities, Miller. AIR 1967 Supreme Court 1910, that is Santram Sharma, I have given para 7 and 8. Then, my lord, AIR, 1979 4 SCC 507, TN Nagarajan, para 25. And, my lord, 1998 8 SCC 469, Kupuswami's case, para 3. So, in all these propositions, the Honorable Supreme Court had said that once the field is covered by a statutory rule, executive power cannot be, or executive fiat cannot be issued to tinker with it. And to that, my learned friend is also agreed, therefore there is no difficulty. Now, the second point which my learned friend asked was, my lord, regarding damage. My lord, regarding damage at page 329, this procedure is given, my lord. The question of damage will come, provided, my lord, my repetition is dismissed. Otherwise, this question will not come. If your lordship is inclined to pay
damage to the accommodation.
Damage means, my lord, that penal rent,
penalty charge.
Penal rent. They call it.
No, but if you accept the
telescopic damage.
If you accept the position under the rules,
yes,
then you have to vacate within 3 years, after
Yes.
3 years.
Yes.
So beyond 3 years, you are entitled, you are required to pay whatever
some
damages,
damages.
something like that.
That I cannot say no. The only thing is there, my submission would be, for your lordship's kind consideration. Why have you not taken me back? Is it not for in the exigencies of public service? I'm still serving in Northeast beyond 3 years. Anyway, that's a different aspect.
Is it a case that you're projecting that this is discriminatory treatment
Yes.
by the central government, in a sense that similarly placed officers are permitted to utilize these
Well,
services?
discrimination on 2 counts. One, same homogeneous group, same officers, when they go to Ladakh, when they go to Milord, Andaman Nicobar, when they go to Jammu and Kashmir, they are not liable to pay. Secondly, Milord, Group B, Group C officers, they are not liable. They are also not liable to pay. Only Group A officers have been picked up for this discriminatory treatment. Anyway, Milord, regarding Group BC officers, I am not very sure whether that 3 year stipulation is there or not. But that up to 3 years they cannot. Now, my lord, my learned friend has also made a submission that even after 3 years somebody has not vacated. Now, that is an aspect which in the individual case the authority will look into it. So that does not come in the way of the principal submission which we have advanced. That is not even our case. And my lord, this my learned friend has also referred to one OM dated 1/8/18. My lord, regarding that there is no pleadings, neither, my lord, that OM has been annexed to the affidavit in opposition. Therefore, so my lord, therefore, my lord, the stand taken by the government of India is somewhat incongruous, my lord. It cannot be, you cannot do hot and cold at the same time. And in fact, my lord, in recent judgment, one of the division bench judgment of the Manipur High Court, my lord, this aspect has been dealt with. If I may be permitted to place the judgment, my lord, it is at page 294 of our additional affidavit. Page 294. Now, please come to paragraph 5 for the facts, my lord, at page 287. The 9 petitioners in the above, has your lordship got it? The 9 petitioners in the above mentioned writ petition are
You are
also
reading para 5.
para 5 for the facts at page
296.
287.
287.
Yes. Oh, you know. I'm sorry. I'm sorry. I'm sorry. Sorry, it starts at page 294.
Yes.
Please come to para 4. The case of the petitioner in WPC so-and-so is that he remained posted in 103 Battalion, New Delhi by drawing HRA with his pay, and after completing his 10-year period of posting at 103 Battalion, petitioner was transferred to 32 Battalion CRPF, Loktak, Surachandrapur district, Manipur. Pursuant to the transfer order dated 29/1/19, he reported duty at 32 BN and Commandant 32 BN had also taken him in the strength of the unit with effect from 15 to 19. By order of the Commandant 32 BN, a sanction was accorded for his entitlement of HRA and was also drawing his HRA with his pay regularly with effect from 15 to 19 without any interruption till March 2020. However, in the month of April, the respondent authority, without giving any opportunity of hearing, without issuing any recovery order, recovered a sum of rupees 27,827 from the petitioner's pay and also stopped HRA of 22,584. After knowing the stoppage of HRA and recovery of so-and-so, petitioner has submitted a representation on so-and-so to the competent authority. Despite receipt of the said representation, Sen has not considered till then, hence this writ petition. So, my lord, since he was posted to Northeast, my lord, he was imposed with his payments. Now, please come to para 41 at page 307. I'm sorry, my lord, Lordship will kindly read also para 40 at page 306, last two sentences, towards the bottom of the page. The purpose and object of granting benefit of HRA is to reward persons who are posted in Northeastern region. When the basis for granting HRA to employees posted in any region is provided, this court fails to understand why respondents are denying benefit of HRA to petitioners who were posted in any region. And the very purpose of giving was because he is posted in Northeast. In Director General versus so-and-so, it was held, the classification as made in the government order does not pass the twin test as noted above. The government, having itself realized the error, has corrected the same by government order dated 3/8/2005, permitted the special duty allowance to all who are posted and serving in the Northeastern region, irrespective of the fact as to whether their headquarters are within the Northeastern region or outside the Northeastern region. So, Lordship knows, and this is a phenomenon which is prevailing in the Northeast, my lord. Whosoever is posted, they are given SDA, special duty allowance. Thus, it is clear from the above decision of the Honorable Supreme Court that there is no intelligible difference between the two classes of employees posted and serving in any region. The policy of law, as is clear from the government notification, is that government came with a scheme of special duty allowance with the object and purpose of encouraging, attracting, and retaining the service of officers in the any region. The two categories, namely whose headquarters are within the any region and whose headquarters are outside the any region, clearly indicate that classification is not founded on any intelligible differential. Nowhere in chapter 15 of FRSR part 4 it is mentioned that HRA is a headquarter based allowance. While issuing the impugned order, the respondent authorities have not stated anything about the specific rule that HRA is a headquarter based allowance. Further, there is no such detachment of headquarters or notional headquarter in any rules or government order granting HRA to government servant posted in the Northeastern region. For the foregoing discussion, this court is of the considered view that petitioners have established their case and also the petitioners are still keeping their families at the last place of posting. And since they were posted in any region, the petitioners are entitled to HRA of the last place of posting. However, without applying the mind and affording an opportunity of hearing, before stopping payment of HRA, respondent authorities have issued the impugned orders which are arbitrary and therefore the same are liable to be set aside. It is not a case of my lord imposing, penalty for withholding the quarters, my lord. It was a case of no, my lord. I am just giving an example, my lord. It was a case of withholding, my lord, the special HRA, which was granted to them. Now, my lord, therefore, this is nothing unusual. When you are, the idea is you are encouraging officers to serve in difficult areas. That's why you're giving.
That's what we want to understand.
Yes.
If it is the case that you are posted to Northeast and beyond 3 years you are not entitled to any accommodation.
Exactly.
One aspect. Then your posting either has to end in Northeast,
yes,
or the benefit will have to continue.
Continue.
The DSGI says that you have your what you call the forces quarters or whatever accommodation are always available. Over and above that, you are given a special.
No, I was only trying to understand, my lord, if an officer has to continue beyond 3 years, not on his own volition, but because that is the call of the duty, then my lord, whether we can say that the imposition of any penal rent will be also an, my lord, excessive.
A penal rent will fall in the compartment of overstaying
3 years.
3 years. That would be dependent
No,
on
I was only trying
whether
to,
the rules.
no, I was
what do
only
the
trying
rules
to
say?
make an additional argument, my lord, for the previous.
Your argument would be, or perhaps is, that when you are giving the continued benefit to other officers,
yes,
why are you excluding us?
yes,
We
therefore you
also
should
fall.
consider these also.
We also fall.
Before extending, before analyzing, you should consider that aspect. Therefore, whether after 3 years it is required, then you take a call. That is my contention. And moreover, my lord, by virtue of stay order, we are operating.
Stay order, were perhaps
No,
the
but-
penalty is not imposed.
No, my lord. When we approached this honorable court, we approached in 23. So, my lord, that principle will apply. Court's order cannot prejudice anybody.
All right.
So, till the date of judgment, my lord, I think, my lord, neither any equity would be created nor it should prejudice anybody.
That we don't know, but see, there are three aspects here. One is the rules.
So, my lord, they have got their
If
own. They
you
have got their no own OM, my lord.
No, if you accept the rules as they are,
Huh.
then 3 years is the cutoff.
Well, to
You
that
know-
extent, even my learned friend is in my lord ad idem. Therefore, there is no difficulty.
Right. So
I am
beyond
making
3
this
years,
argument beyond
3 years, if you stay,
Yes.
then whatever damages.
Please come to 347. They themselves have come up with circular, my lord. In case of stay orders, they will not take any coercive measure.
No, that is okay. But this is not the issue to detain us. on this. What we
Detain,
want
yes,
to
yes,
know is that
Now, kindly say, my lord, stay granted. In fact, referring to the orders passed in the present series of cases. Yes. Yes, 925 is mentioned.
if you are urging the case of parity,
Correct.
then I think you will have to have that some more argument would be necessary
No,
to
my lord.
sustain your claim.
I was only trying to, bring that, my lord, doctrine called actus curiae nememim greveve.
That is
Court's
okay.
order will not prejudice anybody.
All right, court's order will not prejudice you till the date of the judgment.
Yes.
But if that's the only argument,
Yes.
then there is no requirement to go into this parity aspect.
So, my lord, my humble submission is,
No, we are asking you.
Yes, yes.
Are you urging this or not?
no, my lord, I leave with your lordships with the final submission that whatever action they take on, imposing panel, they will take it after the date of judgment. Because that interim order will merge only with the final order to be passed by your lordships. And in fact, my lord, this is one of our prayer also.
So you have abandoned the parity. Yes, Mr.
No, my lord, parity I have not abandoned, my lord. If I get my prayer, if my prayer for parity is allowed, then everything will be in place.
But for
But as a lawyer, we cannot take a chance, my lord. We have to make those alternative arguments also.
alternative, yes, but we are asking, if you're urging it, then you'll have to build up a case on that. Otherwise, we are not going into this aspect of even answering this question if you're not pressing it. That's the whole part of asking you whether you want to press this argument or you want to reconsider and
My lord, I am instructed to make this submission, my lord. If till the date of judgment I am protected, my lord, then I am not.
I'll just point out 2 paragraphs which my lord may take note of on the judgment passed by the Delhi High Court. Page 17 of the judgment, paragraph 34. So far as their own pool quarters, a submission,
there.
the forces their own pool quarters, concluding their arguments. This is not a finding, this is a submission made by the
Para 34.
Para 34. Just take note. Concluding their arguments, they submit that in addition to the GPRA, the CAPF also maintain their own housing stock in the form of departmental pool quarters, and a substantial number of such quarters are currently lying vacant.
No, but that is that is a finding on fact by the Delhi High Court. What is the actual position here?
No, because I made a submission that they have their own quarters, and these particular OMs will refer to only the accommodation under the Directorate of Estates. So they have their own residential pool of accommodation. They can very well avail that.
And in the last paragraph, that will be my answer to the seniors' argument so far as the penalty is concerned. 68, paragraph 68.
Yes.
Turning to the contention of the petitioners that certain charges, penalties have been imposed upon them, we, under our limited jurisdiction, are not inclined to adjudicate the said prayer of the petitioners, or the petitioners are at liberty to move an appropriate application.
Is it your case that if appropriate applications are moved, you're
Why?
willing to?
Because some maybe good sense in the way of my senior will prevail.
My learned friend has made a submission that quarters are available. Milord, for officers, quarters are not available. It is only for lower rank, Milord.
That is why
Or
we
other-
asked him that what is the factual position in these matters?
Milord, if quarters are available, why government of India will give this benefit, Milord, of retaining that quarter in the last place of posting? Milord, end of the day, it's a huge force. Milord, it's not possible to, and as such, India is a huge country with a burgeoning population. It's not possible.
That would not mean, Worship, that the same people will be occupying the quarters to the detriment of the newcomers.
No, that's not that. It's not about who's occupying the quarters, who's not. We are trying to understand the effect of the rules. On the first glance, it appears that these rules are actually applicable to civil service officers. But then you look into it, there is no distinction. It says anyone who's employed under the government, paid from the consolidated fund is entitled to this.
Flush.
Right? Now they are posted out, they are given HRA, etc. In addition to that, is there quarters available? That would certainly be a point to ponder. But that information has to come from you. The learned senior
That means
counsel
there is
says
pleadings in the affidavit that
it
quarters
is-
are available.
no, it is not there. Therefore, we are asking you.
But they can't, Milord, since they don't provide, they can't stay there. For officers, Lord, there was one point of time I was on this side, whereas my learned friend is, I had been to this group center and some other establishment. I don't think the officers stay in the mess, officers' mess. They don't have quarters. There is an additional DIC or rank officer for him, maybe it is there. But it's not a family station for us.
You give us that information.
Flush.
Give it to us. Let us endeavor to find it. Matter has been heard substantially. The question of whether the quarters are available at the respective battalions or the what do you call
Forces.
it? Forces are and are maintained by the forces for the respective
Accommodation of the officers.
grade. What is the group A
Group A
officers? Group A officers. The learned PSDI they address the court on such instruction as may be available. Yeah,
Deep level.
That will again come from him.
Can keep it on 25th if you want, or
Milord, interim orders are there, will continue.
30th July
Yes.
for further hearing. Interim orders wherever passed will continue.
Deep level.
But it is only on this point you give us
Yes, yes.
information.
But that again, I was telling it will come from him. That will come from my learned friend.
But you are the authority, you should have the.
No, I'm representing the Directorate of Estates. Here, the petitioners are officers of the forces.
But then it's better you give.
Yes, exactly. I mean,
Yes.
Deep.
Lordship, I'm assailing a transfer order. That's the Lordship is a lady constable with the ASI with the CRPF. She is a caregiver, sole caregiver, who has a benchmark disability and covered under RPWD Act of 2016.
Yes, Mr. Dotto, what do you think?
My lord, this is a part of no litigation, my lord. It's an earlier, you arranged earlier transfer order. And during the pendency of that petition, uh, petition, my lord, we considered her grievance and retained her in the group center Gauhati till next summer chain of.
Why you are entitled, you have been given the protection for 1 year.
Well, still, my lord, my mother is,
What
my
can, be,
condition is getting serious, man.
what can be done?
I want to forego the promotion also.
My lord,
Is that an option available?
And my lord, they have said that there's no available, but I filed my affidavit in reply that
Where are these rules? These OM
OM is, my lord, I've annexed with my petition.
page number?
Page number, well, there are two ways, Lord will find it. One is at page 74, annex 21.
This OM still stands.
It gets further modified, my lords, at page 76. 24 OM, my lords. Relevant part which covers me, my lords, it's page 78.
So, Mr. Dotto, the OM says that they are to be exempted from routine transfer.
My lord, I have filed our affidavit, my lord. Thereafter, my lord, he was transferred on promotion. He was transferred on promotion. And
All right, the pleadings are exchanged in the matter.
my lord, she is now given undertaking to willing to go anywhere here.
Where is that undertaking?
My lord, as my additional affidavit. My lord, first
Additional
117, my lord, she has submitted the application for taking voluntary
additional affidavit.
additional affidavit, my lord.
Well, due to stress, my lords, she wanted to opt for VRS
Voluntary retirement.
because she is not able to take care of her mother. But due to financial constraints, because she has been paying loan and then these are the duress, my lord, the petitioner applied for VRS, which was under process. And then after that, my lord, she again due to compelling circumstances, my lord, the petitioner, my lords, prayed for my lord, taking back that VRS. And in within that letter of VRS, taking back that VRS, my lords, there is a line in Hindi. Which is translated, my lord, if my transfer order comes, I will proceed. That is not an undertaking, basically. Okay. Page 117, there is a translate.
Here is accepted, my lord.
Here is accepted.
Accepted, my lord. 114, my
again
lord. Page
rejected, my
114.
114.
114.
Then after acceptance, how do you withdraw?
My lord, thereafter submitted the application that VRS should be cancelled, may be cancelled, and I am.
They invoke my lord CCS rule 43. Also, will find it at
And
page
considering his grievance and he, in a application, my lord, he stated that I have managed my family problem, and now I will ready to go. And this is the this is 117, my lord. That he has some liabilities to pay.
You have mentioned that you have employed some woman.
Yes. But this application has to be read in the background of that other application, which compelled her to take VRS. This cannot be did in isolation.
No. Are you saying that this particular application is not signed by you?
No. Well, I'm saying, but this application, it's basically an application for retracting my VRS.
That's right.
Yes, man. They might be line written, but it has to be read in conjunction with the other, my compelling circumstances which led me to go apply for VRS, my lord.
Now, are we to disbelieve this application?
My lord?
Are we to disbelieve this
No,
application?
no.
Then
That is only record. I don't disbelieve, my lord.
Uh-huh.
But that very line, my lord, if my transfer order comes, I'll proceed on transfer. These are under duress because, my lord, I have already demonstrated, my lord, that I'm covered under the act also.
what act?
That PWD Act of 2016, my lord. Caregiver, my lord, that even that OM is made under that act, that very act.
But he is continuing more than 6 years.
You, where is there ever meant that in spite of this application, you are protected? This application was not intended to be expressed. Huh? पता है. The
My lord, I have filed an affidavit.
where
My lord, para 21, page 134. I have dealt with the amendments made in the bottom part, my lord.
page
Page 134.
134.
134. Proceed. Translation is taken again. People transfer order comes, I'll proceed.
When pleadings are complete,
Well,
the matter be listed for hearing the month of August. The orders, if any, will continue.
My lord, my lord,
Let it
he
come
is-
up for hearing.
my lord, because of stay order, he is continuing in the present place of posting for more than 6 years, my lord. Again,
6th of August.
6th of August. Plus there's an interim.
The remote is passed on.
Kindly peruse the order dated 27/5, madam. Earlier order dated 23/3, my lord, the government advocate, mother, stating that our claim was under process.
Yes.
Earlier they had stated so. Now they have stated that since there is a dispute between both the wives, the matter is submitted.
Who's the first wife?
I'm the first.
You're the first wife.
But subsequently, my lord, the year 2017, my lord, decree of divorce has been granted.
Divorce.
Divorce. But that order has not challenged, my lord, and subsequently married the petitioner.
The
Year 2007.
husband of the petitioner superannuated when?
And my lord,
Or
he
he
died
died?
during the course of service, my lord.
He died
Yes,
Right.
Lord.
27/1/2025.
25. And when was the divorce?
Divorce, my lord.
15/12/2017, it was an ex parte judgment, your lordship, in that suit, and I was not aware about the order.
From 17. When did you become aware?
Only when I went to apply for the legal care certificate, your lordship, then I got to know that the second
So
wife
what
was
steps have you taken? Which year did you come to know?
only after the demise of the husband.
Of course. Then what steps have you taken? Has it been appealed against, recalled, what?
We took some time to go to the appropriate forum for appeal.
I have filed affidavit reply, my lord. Kindly check 102, my lord. Page number 102. This is the affidavit filed before the, my lord, both case, my lord. 102, my lord. Filed on 4th August 2017.
Where is that, your name was not entered in the nominee?
No.
Where is the marriage that you say was done?
My lord,
What is the proof?
marriage certificate, my lord, page 69, my lord. After divorce, my lord, there is the petition, my lord.
Also not under challenge.
Not challenge.
Then
Further time.
do whatever you want, but in view of the documents, the department is supposed to take a decision.
We are the divorce proceeding, my lord. And our engaged counsel also filed petition, my lord, seeking adjournment, my lord, for WS. Thereafter, my lord, she has not come, my lord. And thereafter, ex parte decree was passed. In that, my lord, she has not challenged, my lord. That I have also obtained next of kin certificate, my lord. Her name has not
What?
been told.
What instruction is this?
Lordship, that is what, because earlier the instruction I can put for your lordship, they had stated that it is under process. Now they have stated that due to the pendency of the writ petition, it cannot.
My lord, already attained finality, my lord. Passed in the year
Heard
2017.
Mr. K.R. Patgiri, counsel to the petitioner, Mr. D. Bora for the state MS
Be Soren.
E. Soren appearing for
Respondent number 8.
respondent number 8. Petitioner is aggrieved by the non-release of compassionate family pension,
My lord.
which the petitioner claims in lieu of compassionate appointment for the services rendered by her late husband, late Domburu.com. Submitted that the late husband of the petitioner was employed as a lot mandal in Oklahoma Revenue Circle
Subsequently promoted to Canon.
and thereafter promoted to Kanungo,
Canon.
piece of the circle officers who once in the Revenue Circle, Nilamora. So, petitioner, however, expired on 27/1/2025 during course of his service. Stop. Petitioner, the present, petitioner has been expired. Petitioner has submitted, according to the petitioner, her husband died living behind the petitioner and a son born out of the marriage. So it is also submitted earlier. The late husband of the petitioner married one, Srimati Nirupama Borbora, who's respondent number 8. Respondent number 8. And out of the wedlock, one male child was also born. So the year 2017, a suit for divorce was moved by the deceased husband of the petitioner for dissolution of the marriage. So the same was registered as title suit within bracket divorce number 28 of 2017. So subsequently, by order dated 15/12/2017, the divorce petition was allowed ex parte and the marriage was annulled. Marriage between the petitioner's husband and respondent 8 was annulled. So according to the learned counsel of the petitioner, this order has attained finality as no appeal been preferred by the respondent number 8. So thereafter, the marriage was solemnized on 18/1/2019 and registered on 21 9/2023. Between petitioner and her late husband. After the demise of her husband, the petitioner submitted the necessary claims for compassionate family pension. However, the respondents have declined, have failed to accept her claims, and thereby petitioner is before this court filing the present. The circle officer has filed an affidavit. Wherein at para 6, it was stated that the hearing was conducted in the circle office of Subansiri Revenue Circle on 24 March 2025. And a report regarding the same was submitted to the Deputy Commissioner by the communication dated 25/3/2025. However, copy of the said communication is not enclosed to the affidavit. Additional Deputy Commissioner has also filed an affidavit. Service book, along with all necessary enclosures, was submitted to the Additional Deputy Commissioner within bracket Revenue, Lakhimpur. Respondent 8 has also contested the matter by filing the evidence, denying the contentions of the petition. It stated that the late husband obtained the ex parte decree without having copies of the notice being served. So stated that the present petitioner is a retired assistant teacher and a government pensioner. The retired teacher,
Respondent number 8.
the respondent number 8, is a retired assistant teacher and a government pensioner. That are having heard the counsel for the parties and upon perusal of the pleadings available on record. Petitioner filed a rejoinder affidavit reiterating the case predicted in the writ petition. From the pleadings available, it appears that there is the annulment of marriage between the respondent 8 and late Domburu Dr. by order dated so and so, passed by the district court by the in title suit divorce number so and so so and so. So the learned counsel appearing for the respondent number 8 submits that no appeal has been filed against the said decree of divorce. Stop. Petitioner has submitted the legal year certificate before the authorities. So from the averment made in the affidavit, it is seen that the service book of the petitioner is available before the authorities. So under such circumstances, there appears to be no hindrance in processing the claim of the petitioner by the respondent authorities. For making necessary verification to the extent permitted by the rules. So the writ petition therefore stands disposed. The respondent authority, namely C.
Respondent number 5, my lord.
Respondent number 5,
District Commissioner.
District Commissioner Lakhimpur, directed to court process the claim of the compassionate family pension payable to the writ petitioner upon making verification. So, needless to say, the process will be carried out by the Deputy Commissioner in terms of the provisions as permitted under the rules. The exercise will be completed within a period of 60 days from the date of receipt of a certified copy of this order. Therefore, Mr. Talukdar for Accountant General, Mr. Hendik for Revenue, Mr. D. Bora for DC.
356.
356. Disposed.
Item number 49, my lord.
49 is what?
He has filed cross case.
For?
For same.
What is your prayer in 49?
Lordship, for satisfying question the legal has certificate.
Also setting aside the expertise judgment, my lord. He was so read.
What is this writ petition number?
My lord,
357. WPC 357 has been filed by the petitioner whose error is respondent 8 in WPC 4205-25. Seeking a direction to the respondent with the following prayers. 1, 2, 3, 4. Whatever is there. Error. No affidavit has been filed by any of the respondents. Prayer made in the writ petition for interference of the judgment and decree. Judgment dated so and so, decree dated so and so, TS divorce case number so and so. The appeal lies before the DB.
My lord.
I think it has to be filed as first appeal.
My lord, matrimonial.
Matrimonial appeal, MAT. Will have to be essayed before a competent court and as before the division bench of this court as per the rules framed by the under the Gauhati High Court rules. Stop. Insofar as the washment of the next of kin certificate, legal year certificate in favor of respondent 8, the petitioner in WPC 4205 of 2025 is concerned, the same cannot be entertained until the order, judgment and order dated so and so passed in titles to divorce number so and so is interfered with and set aside. Stop. Under such circumstances, view of the judgment and order dated so and so, passing divorce case number so and so, having attained finality and no appeal, proper appeal has been preferred. The claims made by the petitioner are not maintainable according to the same stand dismissed.
Obliged.
Rest of the matters we'll have to take it on some other day.
Item 61 and 62, that may be fixed.
My lord, I have one pair. They are filling up all the posts or in ORSP. So two posts may kindly be kept vacant.
No, that cannot be.
Because my lord, we have filed additional affidavit. Our performance extraordinarily good they have written by
Let it be day
themselves.
after tomorrow, madam. There is an urgency in this matter.
So
So there is
two-
an interim order passed by this honorable court. There is an urgency also in it.
All right,
madam.
day after tomorrow.
Madam. Thank you.
Good.
Item number 70.
Let it come after vacation. 71,
707.
70. Let it be after vacation.
After the date may be fixed, Lordship.
Day after tomorrow is